Mama's in the living room watching Judge Judy. I'm in the kitchen eating leftover sushi. And she yells, oh, girl, you gotta hear this one. A man was arrested for running a theme park. And when they said, where's your license? He said, my dog ate it. Oh, you can't make this shit up. Sometimes I wonder if life's just one big cosmic joke. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on her Prosecco, makes fun of all the weirdos, and then I hear her shout. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on her Prosecco, makes fun of all the weirdos, and then I hear her shout, girl, you gotta hear this one. Mama loves to laugh at how absurd life is, says it's all a comedy and I'm her audience. And I love the way she makes fun of the world. She said, you'll never guess who's with their girlfriend. It was a man who didn't get us out of the bed. He said, I've been through hell and now I need some help. You just can't make this shit up. You just can't make this shit up. Sometimes I wonder if life's just one big cosmic joke. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a Prosecco, makes fun of all the weirdos, and then I hear her shout. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a Prosecco, makes fun of all the weirdos, and then I hear her shout, girl, you gotta hear this one.
Hey guys, welcome back to Petty Playback. We're on day 4, part 2 of the Tyler Robinson preliminary hearing, aka probable cause hearing, that has lasted an eternity. Yes, this is Petty Playback, where real life does not get in the way of this shit show. My hair is wet. I just got off the phone with my daughter's school. That is why I am running just a teeny tiny bit late this morning. However, we have one more witness, I think, from yesterday, which is a defense witness. And how the defense is ever going to prove that yesterday's prosecution was not enough probable cause to move forward towards a trial. Yeah, this should be interesting. I have no makeup. You will see me standing today because I am in a lot of pain from sitting all week. I don't sit this much. This is why I don't sit this much. So we are going to be extra spicy, extra petty, and we might do some day drinking here yet again to keep me sane and to keep me from reaching through my computer and slapping Dickie Novak back into the reality of the fact that his client has enough probable cause to move forth to trial. Is my buddy Flash Fan. How are you?
I am good. I got good enough sleep last night.
I got no sleep last night. I got like 3 hours of sleep last night.
Woo.
Oh yeah. I got 3 hours of sleep last night. I ran 2 miles this morning, if you want to call that running. It was more like a waddle.
It's better than what I could do.
With some weight training in between. It was supposed to be a partner workout, but since I was moving at the absolute snail's pace and there was an odd number of people, I decided to do it by myself. I have no motivation to do anything this morning. I am tired. I am slightly moody. So we are going to get straight into this because we still have a whole day 5 to get into.
Yeah.
Oi. And while we are watching this, I will be setting up day 5 stream. I have to turn down the volume on this. The little won't be joining me all day today because her father is home today. He is just running an errand for my dad. And when he gets home, she will probably go, Daddy's home, and make a beeline for wherever he is in the house. So even if he is on the toilet, she is right there going, hi, Daddy. So
we gotta get through Michael Birchcroft with one witness.
All right, so we left off at, come on, there we go. The 6-ish 15 mark. So we're gonna go.
I hope I counted right.
Well, they took a break right before the defense was going to present one of their witnesses.
Oh no, they was supposed to cross-examine, I believe. The lady was on the stand
Yeah, here we go. This right here. The wrong break. Michael Burt is going to cross-examine.
Direct examination of the sergeant turning to defense. Mr. Burt,
Thank you.
witness.
Good afternoon.
Good afternoon.
Your role in the case was
And this is normal
as the
speed. We don't do normal
traffic
speed here.
manager of the whole operation, right?
That's a good way to put it, yeah.
And we're talking about multiple agencies besides the SBI, correct?
Yes.
I wanted
Your agency, if I'm correct, wrote a.
What was that?
I wanted, does he look like anybody y'all know to Baby Squid?
No. No. So for those of you who wondering why Flash Fan is laughing hysterically for what seems like no reason, one of the prosecutors, McBride, is a younger gentleman who happens to look very, very similar, almost like they could be brothers, to Mr. Squid. So when she saw him on the screen yesterday, she went, "Daddy." No.
No.
I mean, and we're in parrot mode right now, so you know.
Yeah,
Massive report, 229 pages long.
They went out
Yes.
there.
You've read that. You're familiar with it.
With most of them, yes.
Okay. And it's a compilation, right? You authored some reports, but a lot of other people wrote reports about aspects of the investigation.
Yes.
And as those reports were getting done, you would kind of read them and decide what needed to get done further?
Yes.
Was that one of the roles that you performed in this case?
Yes, as well as consulting with the case agents.
Okay. Now, if my count is correct, 9 of those reports in that larger body of reports was written by you, correct?
Yes.
Did I miss any? Does
There are
that sound about right?
Yeah.
Okay. I want to ask you about a couple of those reports. The first report was a report that you wrote on September 22nd that documented the overview of the crime scenes, correct?
Yes.
And there were various crime scenes that you've described on direct examination, correct?
Yes.
One of them was the Fulton Library.
Yes.
Tell us why that was a potential crime scene.
Yeah, of course. When officers were canvassing the scene, they were also trying to see the route of the shooter as well as just trying to find the shooter. And they determined that the Fulton Library stood out because there were unattended items there at the bus stops that were away from the courtyard area, and so to them they thought it was suspicious.
And were certain items seized from, and what were they?
Yes, you had a backpack, a jacket, as well as some gloves, and there may have been some other things. I just don't recall them right now.
And do you recall what the item numbers were of those seizures? Was it 9? Does that ring a bell?
I don't remember.
Whatever was seized was sent to the FBI lab for processing?
Yes.
And along with some information that the suspect may have shed some of these items as he fled, correct?
Yes.
Was a decision at some time made, and you were requesting that both DNA and other type of analysis get done?
Yes.
At some point, did you decide to pull the plug on that?
At the time when it was already sent, we didn't have more information as far as whether or not the evidence that were collected there were probative.
But eventually you communicated to the lab that those items were not in fact connected with the case and there was no need to do further testing.
I don't remember communicating that.
Okay. If that's in the notes of the FBI or the ATF, would that be inconsistent with what you know?
No.
Okay. I mention it because some of the reports, the lab reports, have those items listed.
Okay.
I just want to be clear that those items eventually you determined were not related to this case. Would that be fair?
Yeah, that would be fair.
Okay. The second report, at least as far as I can see, that you wrote was on September 24th, and it had to do with looks like a request for a search of firearms. Do you recall that?
Could you elaborate for me on the firearms?
This document documents that NIBIN request for firearms.
Yes, so that was the request to conduct, what that stands for, the NIBIN, is the National Integrated Ballistics Information Network. It is run by the ATF, and that is where we test or we input test fires or cartridge casings, the head stamps, and whatnot, into a machine that is then run through the ATF to see if there's any other cartridge casings that match.
And nothing of value came from that part of your investigation, correct?
Correct.
Now, going back for a minute to the crime scenes, you talked about the wooded area, and you used the phrase "we."
40 years, and this is the best he can do.
I I miss him when he was 40 or something years old in 1993.
For 40 years of being a lawyer, and this is the best questioning he can come up with. Well, this just goes to show you how technology has changed, and how just because you've been a lawyer for a long time does not mean you understand technology.
Yeah, because
Also, if you are generally, this is another thing that irks me about certain issues. People who are from California and maybe just anti 2A and have no idea about anything pew pew or pew pew related, and then all of a sudden try to ask experts related to pew pews when they don't know what the hell they're talking about, it's interesting.
I need to rewatch in the Menendez case, because that definitely has something to do with ballistics, because they talking about firearm. But
True.
rewatching-
There's a difference between the technology of testing ballistics in the 90s and the technology of testing ballistics in 2025. So, but also, just because you are doing a ballistics or a case involving ballistics, if I have noticed that when people who are anti pew pews and or have never touched a pew pew start to ask questions about pew pews, they look a little lost because they're trying to ask questions about things that they are not comfortable talking about, and it shows.
Yeah,
It kind of shows based on when you're comfortable asking questions and you kind of have a background and you know what you're talking about. You don't have to be an expert, but it's like being handed a weapon and holding it confidently, and being handed a weapon and looking at it like it's about to get up, grow legs, and do something on its own. Like, when someone holds a baby who's never held a baby before, and they're like, it kind of reminds you of that.
Samantha, because I did research on this. In Utah, you have the same judge who presides over the trial due the preliminary hearing. They in the role of a magistrate, but yeah, it'll be the same one. That's the case he decides to recuse himself, or they try to have him or file a motion for him to step down.
Yeah, and this judge has gone from looking like he is not normal, and I don't mean to say normal like that's a bad thing, but he's gone from having like a stoic face and just having that everyday just resting face, not resting bitch face, to just looking unbelievably angry and annoyed at every little thing. Like every time we freeze his face, he looks pissed. And he didn't look like that on Monday.
Yeah, no. Yeah, it's not going to be the last time, unfortunately, that he has to see that video.
Nope.
Seize the towel. Who is we? Who are you referring to when you say we seize the towel?
We would be SBI as well as FBI. So that would be myself as well as FBI Evidence Response Team Lead Michelle Kamak, or Special Agent Michelle Kamak.
So you both reached into the bushes and you both grabbed it and pulled it out?
She did, but I was there with her and we were communicating that entire time.
Okay, so when you say we seize a towel, what you really mean is she sees a towel and you observed her seize it.
Yes.
And when she sees a towel,
Michael Burt, only one person can touch the damn thing at a time. It's not like they held hands and skipped through the woods.
Yeah, digital technology and all this stuff has definitely came a long way since it's heyday.
He's making it sound like, well, you didn't do it and you wrote about it. This whole line of questioning to me is like, well, you wrote about hearsay. I feel like that's where he's going. And it's one of those things of like, dude, you're wasting more time that you don't have on something that's been decided weeks ago.
Yeah, I believe they got 2 more witnesses left. I'm interested to see what they're going to call, who they're going to call. Probably more ballistic stuff, which isn't going to land well, probably.
And Flash Fan, I'm turning you up a little bit. You're a little quiet compared to everything else. There we go.
I just need to learn how to project.
I just turned you up a little bit. I have a little more power to affect each individual person's audio than I did in StreamYard. It's kind of cool.
Can you describe a little bit more detail of how that process took place?
As far as when it was found or when
Yeah,
she removed it?
yeah, the photographs you showed us, were those the best photos you've got of that process?
That was taken by the FBI, so that's all we got.
That's all you got. And nobody was videoing the discovery and recovery of that evidence?
I believe one of the officers on scene actually had his body camera on.
And have you seen that?
I have not.
Do you know if there's any documentation of the exact process by which that towel got removed from the rifle and then, I guess, put back on the rifle, right?
No, it was not.
It was not put back on?
No.
Didn't one of the photos show the rifle in the box with a towel over it?
Yes, it wasn't over it. It was still wrapped around the gun.
Okay, but as I understood your testimony, the towel was seized by the FBI agent, and then somebody must have reached in and got the gun out, right?
No, I'll clarify for you. So
Sure.
the entire time when we retrieved it, the gun was wrapped in the towel. So when Special Agent Kamak reached in, she grabbed not only the towel but also the gun. And it remained, and the towel and the gun remained basically intact, lack of a better word, and then was placed onto the cardboard box, which is one of the photos that was shown earlier. Once we documented that, and then the towel was removed from the gun.
You also mentioned as to the other crime scenes that we processed it, but was your role in terms of your actual participation limited to the wooded area? Or were you involved in actually seizing evidence at the other locations, like the roof?
Yeah, I was involved in coordinating all that and then determining from there where the evidence would go.
Involved in, is that the same thing as actually being on the roof and seizing the items? Or are we talking about something else?
Talking about something else.
And what is that something
So
else?
after the teams would have packaged all the items, sealed them properly, created an evidence log, they would then bring it back to the command post, and from there we would compile everything, and then there was a discussion that was had as to who would take custody.
Fair to say that you did not observe yourself the seizure of the screwdriver from the roof?
Correct.
And who were the people who were actually conducting that part of the crime scene process?
That would have been our state.
He's gonna go into, well, you wrote about it and it's hearsay. It's just this is a waste of fucking time. A giant ass waste of time. It's almost like the defense is wanting to practice run if they're arguing admissibility or in front of a jury. That's what it seems like. Like
To
they're
me, it seemed like they trying to litigate the whole case preliminary hearing, where this stuff could be handled in future hearings.
I agree. They're arguing things that are not appropriate for a preliminary hearing, and I just don't get it. It's a waste of, at this point, it's a waste of time. Because, like, it's a waste of time. And stop wrapping your hair. Thank you.
State Crime Lab, those two people are part of our State Crime Lab's crime scene response team.
When did you review the video of the suspect running toward the area from which he jumped off?
That would have been, I don't know the exact time, but it would have been the day on September 10th.
You saw that on September 10th?
Yes.
And when were the windows processed for the latent fingerprints?
The windows were processed on September 11th, the next day.
And was the reason that those latent lists were taken was because you wanted to rule out whether the suspect had touched that window?
Yes.
That's what the notes say, right?
Yes.
You were not present when that scene was processed either, correct?
Not the entire time, no.
Okay. Now, the other reports that I have that you did, and correct me if I'm wrong, is one report dated September 24th, documenting the forensic analysis as of September 24th, summarizing what you were hearing back from the ATF and the FBI.
Yes.
Okay. And then the fifth report was, again, about the crime scene progress of the forensic testing, right?
Yes.
Right? And then you have a report here which documents a firearm trace and a firearm seized at River Street.
Yes.
Nothing of value came of that, correct?
Correct.
You have a report that has to do with the latent print report from your people, SBI.
Yes, it's not SBI, it's actually the State Crime Lab, but yes, same department.
Same department. Just detailing the results of that examination, which the stipulation addressed,
Yes.
right? You have a report documenting the transfer of evidence from the FBI to your department.
Yes.
And then the last one that I have that you personally wrote has to do with, again, summarizing forensic reports.
Yes.
Okay. The larger 229-page report indicates that there was some investigation done by your agency that involved interviewing associates of Mr. Robinson to see if you could develop some profile of him having animosity toward Mr. Kirk, correct?
I'm not familiar with that.
So you weren't involved in that at all?
No.
Some
Why
of
would
the
she?
documents in that large report indicates that your agency has.
Why would she be involved with that? She's only looking at ballistics. I think you're muted here, Sanson. Or maybe it's just not audio. Hold on. She's only looking at ballistics. Yeah,
I am muted.
I guess say is she muted or?
Yeah, I'm muted. Thanks, Jeffrey. So it's almost like he's trying to discredit everything that she says because of what she had testified to, with being the one who noticed that the spent casings were not removed from the weapon. That the spent casing that was not removed from the weapon had the same engravings as the casings at his apartment, with the Dremel tool and I'm assuming the the marks on the casings matched the Dremel tool that was found in his apartment. And because she was the one that said all that with her testimony, with, I say yesterday, but it's literally the same day. We're
Yeah,
just
it
not the
literally.
next day.
For them, it was literally about what 2 hours or so ago.
Yeah, for them it was 2 hours ago. For us, it was like 18 hours ago. However, with those with that issue, because she was the one who brought all that up, they're trying to discredit her any way possible. I don't think it's working. I think it's making them look stupid. However, for some reason, I feel like that's their end game.
Also, up to the present time, been monitoring Mr. Robinson's mail and communications at the jail. Correct?
Correct?
And have you kept abreast of that investigation?
No.
Do you know whether anything of value has been developed as a result of that?
No.
That's all I have. Thank you.
Thank you, Mr. Burt. Redirect. All
Anything run super long.
right, may this witness be excused. All right, Sergeant. Thank you.
The thing, like, we don't even need no redirect.
Turning to the state. Appreciate creating a good record.
Judge, if I could just confirm with the court that all of the exhibits we have offered have been admitted into evidence.
All right, so here's what I have, and my court clerk will certainly correct me if I'm
thinking
mistaken.
this is not important for us.
6.17, I have
All of it.
or not public.
Your Honor, the state rests its case in chief.
On petty playback, we get rid of the shit that's not important, and them talking about what exhibits have been admitted is not important to us.
Thank you. Turning to defense.
Okay.
Approach the bench, please.
Okay.
All right, so they're taking a
Sidebar.
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 Family has asked that all exhibits admitted into evidence be shown here in open court. We're grateful to the court
Oh, they
for
argue.
allowing the family.
This is the attorney representing the family.
Yeah.
Just FYI, for those of you who did not watch yesterday, this is that attorney.
To view many or most of the exhibits today that were admitted. They were viewed here openly in court. And obviously that was done after the court struck what we think is the appropriate balance after a very thoughtful and thorough analysis. I'm going to ask the court to reconsider one of its prior rulings. I understand reconsideration is always a big ask, but I do think, Your Honor, that if the court were to display publicly, or just in the courtroom, Exhibit 12.1, which is the enhanced video, version 12.4, which was played in court, was very hard for the family to view. We think that we ask the court, since the court's considering it, the family should be able to view it as well. When conducting the appropriate balancing, the court, as the court knows, can alleviate any concerns about proper jury selection with certain tools at its disposal. However, if the court were to deny the family the right to view that video, there's no cure. It's either they get to do it or they don't. So we would ask the court to reconsider its prior ruling and to display just in the courtroom Exhibit 12.
What was that?
I was Samantha, you get the impatient squid today.
Well, no, it's just I'm not wanting to talk about things that, like, what exhibits have been admitted to the court. That's not relevant for us.
Yeah.
Their
I'm just-
procedural crap is not important. It's not relevant. It's boring. Like jury instructions, those are relevant. They're boring, but they're relevant. So we listen. Them talking about what exhibits have been admitted and just double checking that everything that they submitted was admitted, not relevant. Don't care. Do not care. I don't care on Monday and I don't care today. Like that's not a, oh, I'm getting impatient. No, that's just I don't care either day. This is the first time that I've actually streamed 5 days in a row of courtroom footage.
Yeah,
So I'm getting back into the swing of how I did night court and what I skipped and what I didn't and why I skipped it. So for those of you who are new to my channel, I used to do night court where we replay a day of court footage of a trial, but we do it at night, 1.5, 1.75 speed, skipping the sidebars, skipping the procedural crap that no one gave a shit about.
Yeah.
That was not relevant to us as the jury, was not relevant to us as viewers, did not care, do not give a shit, skipped it. And
She streamed one live trial, and that's that. She's like, nope, not no more.
Nope. I don't have the time. Y'all can see how long this takes. Exhibit A, 2 YouTube channels, a job, and a household to run. This is not streaming trials is not my yeah. I'm not sure they care about you don't care. You don't care. Yeah, you go. It's like it's if it was relevant to moving the story along and it was facts that were needed, I would move things along. However, it's not relevant. So yeah. But this is the attorney for the family. So
One, which is the enhanced video. Thank you, Your Honor.
Thank you. Turning to the parties, starting with the state, Mr. Grunander.
Thank you, Judge. The state does not oppose publishing 12.4 in the courtroom. I think we've tried to make it very clear throughout this case.
the defense is going to argue this, and it's going to be 20 minutes.
That we favor openness and transparency as much as appropriate. I'll submit it on that.
Thank you, Mr. Grunander. To defense, Mr. Burt.
My apologies. That's 12.1, not 12.4.
Thank you.
Judge, at this point in the proceeding, we're asking the court to keep focus on the purpose of this hearing. And as the justice...
You don't keep track of you aren't keeping on the focus of this hearing. This is a probable cause hearing. You've been asking procedural questions and evidentiary questions that are not appropriate for a probable cause hearing.
Man, this guy
So you asking the judge to remember why we're here is falling on deaf fucking ears, and nobody cares, Mr. Burt. Sit your ass down and shut the fuck up.
This is said in the Essex case, the purpose of a trial, and I know this isn't a trial, but the same logic applies, is to determine the defendant's guilt. It's not to educate the public or the victim's family or the world on what evidence...
is not to determine guilt. What are you talking about?
No. A probable cause hearing is to show the evidence you have. It's a public hearing, and the public is very interested in what evidence you have and the state has. And if you're hiding evidence, why are you hiding evidence? If your client didn't do shit, if your client is innocent, why are you hiding evidence?
I used to like him, man. I really did. Woo.
The older you get, the saltier you get. I'm warning you. I think he's another one in the urinalysis line for a UTI because there's something not right in that head.
the government or the state has. As the court knows, we have witness availability problems. We spent the bulk of today and yesterday arguing about nothing to do with the evidence in the case, but with rights of third parties.
No, Mr. Burt. You have spent the better part of 2 days. Yeah, tell him. Yeah, not the court, not the prosecution, not the media, not the family. You are the only one who is opposing.
The state is the one that's saying we don't oppose it. They like, well, yes, objection, Your Honor. Like,
yeah, you are the one who is making this a shit show.
And it's appropriate for the court to consider that. But at some point, I think the court has to return to the purpose of these hearings, which is to expeditiously hear the evidence and then determine probable cause. And I want to point out to the court, Ms. Kirk has been very adept at holding press conferences at which she has revealed evidence.
Oh, shut the fuck up.
Don't victim blame. Do not do that.
Oh, yeah, that's not going to go over well.
She has represented that the state is her attorney. She has access to all the evidence that the state has publicized and that the media and her own lawyer argues is already in the public domain. So they're perfectly free to go outside this courtroom under the court's protective order. They're free to go out and hold press conferences and announce to the world outside the courtroom what they think the evidence is. They have the availability of that evidence. But the court's role, I think, at some point is to exercise some control, move the case forward, and especially when we have witness availability problems. And I'd ask the court, whatever the court does, if you're going to allow revisiting or replaying of evidence for the sole purpose of...
What was that?
I said they better stop before the Kirk family do what the Goldman and Brown family did in the Simpson case. They went out and trashed the Dream Team in press conferences. They going to have the situation right now.
Yeah, and this is not this is how to ruin your legal career in 30 seconds or less. I'm just saying, victim blaming when there are millions of people, like, it's one thing to victim blame, and I don't encourage victim blaming at all. However, on the scale of shit, if someone is involved in a drug deal, for example, and a drug deal goes bad, well, the defense might be able to say, well, the victim was involved in nefarious activity.
Like the argument in his case, the Menendez case, that was where victim blaming was warranted, because I believe the stuff he said was true.
For example, a situation such as that, where it's a self-defense, borderline self-defense case, where the victim could possibly be viewed as a perpetrator. That is different than someone who is talking, having a conversation in a public domain, and is shot in the neck and unalived on the internet. And you're going to blame him and his wife. And there are a lot of people who blame his wife and think his wife did it. So I completely understand why she wants a public hearing to be public. To be like, here's what the court, I have nothing to do with the prosecution. I have nothing to do with the FBI, the Utah State Bureau of Investigation, what they found, the reports that they write, the opinions. I have nothing to do with that. So see, it is not me. This is the guy that they think did it. This is the evidence that they have against him. It's not me that they're going after. Like, Candace Owens, man, she's a hot mess and a half. And
I've heard bad things. I don't really know who she is, but I've heard nothing but bad things.
She did some. She's a conspiracy theorist. But yet she claims to be like, I was best friends with Charlie Kirk. No, Charlie hadn't talked to you in a long time. And there are probably reasons for that. And the fact that you went off the deep end is one of them. So we're just going to...
informing the world or Ms. Kirk or anybody else that the court do it at the end of the process and not at this point where we will be deprived of our ability to call this witness, because she has to be done today.
Thank you, Mr. Byrd.
Thank you.
Briefly, and I say that because time is of the essence, not because I don't want to hear what you have to say.
I understand, but there was a lot that was just said that's just not true.
So let me put this in a spot where we need to be. And I understand that there's opinions, but I have to keep this to the probable cause. I don't want this to go to a back and forth about issues that lie outside of probable cause. And I realize...
Why are you blaming him, Judge Graham? It's not his fault. He's representing his client, the family. The defense is the one that's objecting and making it about it.
Yeah. I did. Yeah. I agree.
That's the first disagreement what I have. That's the first agreement I really have with this judge. It's not his.
It's the defendant's. Sure, it's the defendant and the defense that's making it all about not public. The state's like, I don't care either way. The family's like, make it all public. The media's like, I'm whatever the prosecution.
I would like to be public, but I understand. Do what you gotta do.
Everybody else is like, whatever the court wants, and the family would like it public, but whatever the court just ultimately decides, and the defense is the only one putting up a fight. 3 different parties the prosecution, the family's attorney, and the media's attorney. And the defense is the only one out of the 4 who is putting up a fight.
Statements are made, and as the victim's representative attorney, you want to address it. So I will hear you, but we need to be brief. So if you can be succinct, I definitely want to hear what you have to say.
Your Honor, I am almost always brief, I promise you. The family's not seeing this video. It hasn't. It doesn't have access to the evidence the state has. The state is the state, and Mrs. Kirk and the family have their representatives. That is a complete distortion of reality that was just put forth.
And I feel like that was done as a dig to the family, and the media would take hold of that, and they did.
Again, it's victim blaming without indirect victim blaming.
It's Michael Burt and fucking Dickie Novak putting shit out there. Look, little tidbits of like, well, she has it. She has it. She could show you. No, she fucking doesn't.
Yeah,
like that's not how shit. They're taking advantage of people being stupid. They're taking advantage of people not knowing how the criminal justice system works, how the court system works, how the rules of evidence works. They're taking advantage of people being stupid.
Yeah, I lose all respect for people when they start victim blaming. That's not right.
And this isn't about educating anybody about anything. This is about allowing the family to see the evidence that's been gathered after a 10-month investigation in which a father, a husband was assassinated. That's what this is about. So we ask you to please allow the family to view the video like the court has viewed in order to allow the family to process this moment.
Thank you.
Thank you.
Anything further before the court issues its ruling and we go from there?
Not from the state.
All right. Defense? All right. All right. So I recognize that the Utah Constitution under Article 1, Section 28 recognizes victims' rights, and the court respects those rights, and as it's been previously stated, balances those rights with the constitutional rights of all parties. I will reserve my ruling on that and maybe revisit it tomorrow. But because we have an issue of expiring time and one witness that needs to leave today, I need to turn to that. I'm not ruling that cannot happen, but for today, we need to focus on this to getting this defense witness on the stand and off the stand. And so please, if I do not remember, the parties can remind me and we can revisit this tomorrow. So again, I'm not saying yes, I'm not saying no. I'm simply saying we need to get to this witness, and I'm happy to readdress this tomorrow. Okay? All right. Mr. Burt. All right. Samantha Carner is being requested. If you can go ahead and retrieve somebody grabbing. Mind coming forward right by her.
You solemnly swear that the testimony you're about to give now before the court will be the
Stand to your left. Wouldn't mind pulling that microphone toward you.
Name, please.
Yes, my name is Samantha Carner.
And Ms. Garner, what do you do for a living?
I am a firearm and toolmark examiner.
And where are you stationed?
I currently work at the Forensic Science Laboratory in Washington for the Bureau of Alcohol, Tobacco, Firearms, and Explosives.
And how long have you been employed at that location?
A little over 6 years.
What generally do you do there? What area of expertise do you have?
I am assigned to the firearm and toolmark unit, so I receive items of evidence related to firearms, tools, toolmarks, and fired ammunition components.
At the request of the state of Utah, did you conduct certain examinations relevant to this case?
I did, yes.
Could you bring up State 32 in evidence?
Yeah.
And do you want it, Mr. Burt?
Yes, I think.
On all screens?
All screens. It's admitted and
Okay.
I think
All
approved
right,
for
let's go ahead and
publication.
put it on all screens because this was admitted and published previously.
Okay.
All right.
Do you recognize plaintiff's exhibit number 32?
I do, yes.
Are you the author of this report?
I am, yes.
Okay. What were you asked to do in relation to the examination that's documented in this report?
For the Submission 1 report, I received a firearm, cartridge case, 3 cartridges, 1 bullet jacket fragment, and 4 lead fragments. I was asked to test fire the firearm and compare the test fires to the cartridge case and the bullet jacket fragment. I also was asked to do a tool mark characterization on the cartridge case and the cartridges, and then I also ran a
Yeah, he does talk very slow. He does talk very slow, and we need to get through a lot of shit today. So, yeah. Mr. Rogers on Valium. That's a very good way of describing his voice. I wish he spoke more like Judge Arthur in Mississippi, where he's commanding of his courtroom.
Or even like Judge Crane in Florida.
Or even like the judge in Carroll County, Georgia, with the TikTok. I can see his face, but I can't.
Sarah Grace Patrick's case?
Yeah, with the Sarah Grace Patrick.
Judge
case.
Hightower.
Dustin Hightower. Yeah, him.
That's
He's
the most
too nice. This is like the guy that would hold your hand and like tell you everything's gonna be okay. And like this is not what the world needs right now.
I need to see what's going on with Sarah Grace Patrick. I haven't heard anything about that one. Wow.
Yeah, I have to
General
look it up.
rifling characteristic search on the bullet jacket fragment.
Okay. And are your conclusions accurately documented in your report?
Yes.
Could you turn to page 2 of the report? Second, bottom of the page. Those 2 paragraphs, please. Did you write in your report, these conclusions conform with the relevant Department of Justice policy on uniform language for testimony?
Yes, that is always added to our reports.
And do you have a standard operating procedure that requires that in each examination you do, this language has to be in there?
We do, yes.
Okay. And I want to ask you to review the document that is referenced in that language, which would be, and this is just for her only, Exhibit 11. Let me know when you can see that. Are you able to view that?
Yes.
Is this the ATS, is this a language referred to in your report?
It is,
The
yes.
written policy of the Department of Justice concerning uniform language for testimony and reports for the forensic firearm tool mark discipline pattern examination?
It is, yes.
I move that into evidence.
This is, what is the title of this exhibit?
Your Honor, this would be Carner 11,
All right, and what level of publication are you requesting, Mr. Bird?
both public and admittance into evidence.
To the state.
No objection.
All right, and Carner 11 is
See, this is
admitted
what
into
I
evidence,
don't
may be published on.
Huh?
This is what I don't like about them. They want their stuff published, but they don't want the state to publish anything.
Yeah, because they want stuff published to the public that makes them look good. This is the ATF report that was in the news that was misrepresented in the news when the fragments were inconclusive, and people
Also,
were
this
like,
is-
the bullet doesn't match.
Also, this is another witness like they did day before yesterday or day before that, where they called a witness and essentially to cross-examine them. This is technically a state person, but they're calling it an adverse witness.
It's so dumb. It's so stupid.
They're challenging
Screens and captured by the camera.
Ms. Carner, can you tell us what the purpose and scope of this document is?
Yes, this is the DOJ Department of Justice's uniform language for testimony and report, and it standardizes the appropriate language an examiner will use during reporting and their testimony. And DOJ published this to standardize the wording that examiners would use across their forensic laboratories.
And was this published in part because of some criticism that the prior testimony, not by you, but by other people, may have gone beyond the bounds of science?
I don't know why DOJ published it. It was before my time.
Do you know how long this has been the policy of the Department of Justice?
I do not off the top of my head know.
Are the reports that you issued in relation to this case in conformity with this policy?
They are, yes.
Okay. Now, could you go to page 3 of that report? Where it says correct?
I am, yes.
And the portion of the policy that says, a conclusion provided during testimony or in a report is ultimately an examiner's decision and is not based on a statistically derived or verified measurement or comparison to all other firearms or tool marks. Therefore, an examiner shall not, and then it lists several propositions. You're familiar with that language?
I am, yes.
And it says that an examiner shall not assert that a source identification or a source exclusion conclusion is based on uniqueness of an item of evidence. Your report is not meant to imply something contrary to what's stated here, is it?
No, it's not meant to contract.
You're not asserting that a source identification is based on the uniqueness of an item of evidence.
No, I am not.
And the reason you're not doing that is because you haven't examined all possible items of evidence that could be relevant to your comparisons, correct?
I have not looked at every firearm that's been manufactured in the world, nor have I looked at every tool that's been manufactured in the world. That's correct.
Okay. The second portion of that says an examiner shall not use the term individualize or individualization when describing a source conclusion. Did you abide by that policy in this case?
I did, yes.
And you're not expressing an opinion here that the comparisons that you made are individualized to a particular weapon or a particular cartridge case, correct?
My conclusion for one of the exhibits identifies the cartridge case as being fired in the firearm.
Mm-hmm.
But that's all it says, yes.
Right, but you're not asserting that that's an individualized identification in the sense that's being used in this policy, are you?
No, I'm not.
Okay, and then the third part of that says that an examiner shall not assert that two tool marks originated from the same source to the exclusion of all other sources. You're not expressing that opinion either, are you?
I am not, no.
It says an examiner shall not assert that examinations conducted in the forensic firearms tool mark discipline are infallible. You're not asserting that.
I am not, no.
You're not asserting that. It says the examiner shall not assert that there is a zero error rate. You're not
Correct.
making that assertion.
No.
Okay. says an examiner shall not provide a conclusion that includes a statistic or numerical degree of probability except when based on relevant and appropriate data. You didn't conduct such an analysis here, correct?
I did not know.
Okay. And it says an examiner shall not cite the number of examinations conducted in the forensic firearm tool mark discipline performed in his or her career as a direct measure for the accuracy of a conclusion provided. You didn't do that, and you're not doing that here, correct?
Correct.
And then it says, an examiner shall not assert that two tool marks originated from the same source with absolute or 100% certainty, or use the expressions reasonable degree of scientific certainty,
Special
reasonable
degree.
scientific certainty, or similar assertions of reasonable certainty in either reports or testimony, unless required to do so by a judge. You're not making any such assertions in this case, are you?
I am not.
Okay. All right, thank you. You can take that down. Now, when you conducted your analysis in this case, and in all cases, do you typically generate a case file that includes proper documentation of your examination?
I do, yes.
And did you do that in this case?
I did.
Could you display to her alone, please, Exhibit 6, Coroner 6? Case file. Yes. Is this your case file?
It is, yes.
Did you rely on the documents and photographs that are documented here in writing the report that the state introduced into evidence here?
How so?
Before you
That's
wrote
a
your
better
report,
question.
did you photograph items that you were looking at, take other notes, and then use that work product to
It's
form
like he had
the
this
opinions you
moment where he
reached that are
gets
documented in the
stuff,
report?
but
He's senile. I'm convinced he needs a slums. And if for anybody, when I say slums, from an OT standpoint, that is the St. Louis University Mental Status Exam. It's a one-page questionnaire, standardized exam screening for cognitive function.
yeah, she's not saying people live in the slums.
No, but it's the acronym is slums, and it's the one OT used on acute care in my hospital. So I can probably do that in my sleep. I can probably give you the slums exam live without having to have the paper in front of me because I've given it so many times.
That's the thing, Samantha.
I-
You don't need reasonable doubt this here.
No, I just feel the need to sometimes clarify. Like when I said he needed a UTI the other day, I wasn't talking about the fact that I think he's on drugs. I think when he needed a urinalysis, I think he has a UTI that's affecting his cognition. It was a medical joke, but I know how that can be misinterpreted. Oh, she thinks the lawyer's on drugs. No, I think the lawyer has a mental problem, but I think he needs a urinalysis because a UTI when you're that old can affect your cognition. So I was basically calling him old and cognitively impaired in one sentence.
Yeah, because he had this flurries where he would just go all in. I'm like, God, okay, this is the bird I remember. But then he had moments like this. I'm
Like y'all have it's like you have a warped sense of reality right now, sir. You might need a doctor. You might need a doctor. All right.
But
The
yeah,
notes are mostly used for initial documentation and evaluation, and then yes, supplement to the conclusions that I make. It's all a representative image of what my conclusions are going to be. So part of it is going into the conclusion statement and then just showing proof of those conclusions.
Right, and your standard operating procedure requires that you document in your case file the basis for your opinions, correct?
Yes.
I'd move Coroner 6 into evidence.
To the state.
Is this the 47-page document?
Yes.
I object. I don't see the relevance of the court's probable cause determination to review a 46-page report that includes notes.
Would you like to respond, Mr. Burke?
Yes, Your Honor, this is the basis and documentation of the conclusions reached in the expert's brief report, which expresses her ultimate conclusion, but does not contain any of the reason for that conclusion. So it's important for the court, I think, to understand why and how she reached the conclusions that she did.
All right. Anything further?
No?
Yes, just that without testimony about what the meaning of the notes is and so forth, it is
don't really matter.
more confusing than it is probative.
That's McBride. That's the prosecutor that the little one looked at and said, "Daddy." Oh my goodness.
Notice she didn't say Michael Burke looked like anymore.
Well. Anyway.
So under a 403 analysis, I don't think it's admissible nor helpful to the state, to the court.
All right. Mr. Burke?
I intend to focus on particular photographs which document what she received in evidence and the comparisons that she did, which are also documented in this file in the way of comparison photographs.
This is all for the media right now. This is all for the bullet analysis and the fragments, inconclusive, which means a warped sense. It's like the whole we're not friends thing. Just because we're not friends doesn't mean we're enemies. or we hate each other, or I hate someone. We're friends means we don't know each other. Inconclusive doesn't mean they didn't match. It just means they don't have enough information to know for sure.
Yeah, they just putting on the show. They don't have no holes to poke in the state's case with this probable cause stuff. They just throwing stuff in the back like, look, media, this is they don't have enough. It doesn't match.
Samantha Shoe Lover, it's been like this all week.
Oh yeah,
All week. Monday it was Kathy Nestor, and if you were around, or if you hung around Mo's channel for when she did Corey Richards, you know Kathy Nestor. Kathy Nestor was the queen of objections. We called her Karen Nestor. We haven't come up with a nickname for Michael Burt yet. But
it's hard to come up with something for his name. Nothing
we
really
have
rhymes with
Karen
Mike.
Nestor and we have Dickie Novak. So
Nothing really rhymes with Michael and Burt yet.
I'm very proud of Dickie Novak. I don't know why, but it just rolls off the tongue.
As it relates to the objection is overruled. I find that this is relevant as it relates to State's Exhibit 30, which was admitted, as well as State's Exhibit 30.
I just love when certain people are like, she's making fun of me, or it's like, do you realize that I make fun of every lawyer on the fucking internet that is available to be made fun of?
Yeah, that's why I'm afraid to become an attorney. If I'm ever in the courtroom, you stream the case, you be like, yeah, this guy.
Every attorney that writes something, I put my opinion out there.
Oh, you would hate my writing. I don't know. I'm not a great speller.
Well, but it's like the people who are like, she's the woman who was like, she's harassing me. Do you understand what I do for a living, ma'am? Like, do you understand? I make fun of every lawyer. It doesn't matter if I like them or I'm not, or I don't like them. Like, even this McBride, I tend to like him as an attorney, but I still made fun of him and the questioning and the fact that he couldn't get his audio right on a Zoom call. I made fun of that.
We made fun of the Sarah Boone prosecutor's last name Cacciatore. I'm like, okay, Mr. Chicken Cacciatore.
Yeah, exactly. So the person who was like, he's harassing me. Like, no, I make fun of everybody, but I don't still make fun of lawyers. Like, I make fun of everybody. It's just what we do. We just joke about everybody because we can.
People at church, they're like, I can't believe you actually said that to you. Cause I'd be clowning on my family. We clown on each other. That's how we show we love each other. We just talk about each other.
Yeah, like if Spawn and I are ever super nice to each other, you know, there's a problem. just FYI, like veterans. Like, I don't go hi, what's up? It's like, hey, fucker, how are you today? What's up, loser? Like, you know, you call people names. But if you didn't know that and you come up, it's like, why are you guys so mad at each other? We're not. That's just how we talk to each other.
I was laughing when we did voice chat the other day. I'm so glad they can't hear me because I was laughing hard as I don't know what.
I was like, that's just how we talk to each other. Well, welcome to this bickering back and forth. Like, welcome to the way we talk. Yeah. Humor to deal with the BS. Yes.
Yeah.
And also, like, lawyers are just in general sometimes some of the stuffiest people and like the most uptight people on the planet. So it's fun to just make jokes.
And get offended on that, apparently.
They get
according to some of the
more the people see it. And I am that kind of person where the more someone gets offended by the stupidest stuff, the more I do that stupid stuff.
I've been timed out by more on YouTube because I express my opinion. Like, you don't agree? I'm like, am I supposed to agree with everything you say?
No, that's called being brainwashed. That's why I like when people in the chat don't necessarily agree with me. Like, we might agree on like the overarching topic, but not how to get there.
Yeah.
Not the process. Because if everybody agreed all the time, that would be a really boring world, a really boring channel.
Just like me and you, we don't agree on the fact that Cardi Gray should have got life without parole. I don't think a teenager should have got life without parole. But we still communicate. We still cool.
Yeah, you can have the same opinion that someone needs to be punished and not agree on how. Yes, no groupthink here. Yes, we might agree on like the same results. Like, yes, someone needs to be punished, but disagree on how. But it's a respect thing. It's also like the if we all agreed all the time on everything, that's called being brainwashed. We don't do that here either. So, nope. So
32, which is admitted, and the state is able to do cross-examination on this witness as it relates to this report. And so it is admitted and may be published on all levels in the courtroom and on through the media.
In your report, 1 bullet jacket fragment and 4 lead fragments, correct?
Yes.
Were you informed at some point that there was a discrepancy between what you were examining and what had been documented by the medical examiner in terms of the number of bullet fragments?
I was, yes.
Were you asked to see if maybe the ATF had lost certain portions of the evidence?
No, I was not.
Right. Do you think, and was it your understanding that there were originally 7 bullet fragments, but you ended up with 4?
I was alerted that there was potentially 7 fragments from the medical examiner in a photo just a few months ago.
Okay. You're clear, though, that when you got the evidence, it was in a sealed condition, correct?
It was, yes.
And when you opened, what was it, an envelope?
A small individual manila envelope, yes.
And did you take
Oh, not a
the
red solo.
contents of the envelope containing the bullet and take photographs of it?
I did, yes.
Hey, question,
Okay.
you have some feedback.
Could you display page 41 of 47, that exhibit? I'm sorry, page 14. Tell us what's depicted here.
Yes, this is a picture of the as-received condition of Exhibit 6 in its entirety. That's the top picture. So you'll see Exhibit 6A all the way through 6E in descending order. And then the bottom 2 photos on the left is the Exhibit 6A bullet jacket fragment, and that is the view of the exterior. And then the photograph on the right is the Exhibit 6A bullet jacket fragment, and that's the view of the interior of it.
Okay, now after you documented what the bullet and the fragments look like, did you do certain procedures on the bullet, the larger bullet fragment?
I did, yes.
And what did you do?
I cleaned the bullet jacket fragment, and I also peeled the petals back. If you think of a banana and peeling the skin away from the interior, it's almost like doing that. As you can see from the photo, the petals have been crumpled in on themselves. So in order for me to see the land and groove impressions, which holds those individual characteristics needed for a comparison, I have to do some maneuvering of those petals.
And how do you do that? Do you use an instrument to peel back the portions that you want to look at?
I use pliers.
Okay, and after you did that procedure, did you then photograph the larger bullet fragment itself?
I did, yes.
Were the smaller fragments essentially not of any value to you in terms of doing comparisons?
They were deemed unsuitable, which means there are no microscopic marks of value for comparison.
Okay, but the larger fragment, after you did the process you just explained, you then photographed it again, correct?
That is correct, yes.
Could you display the next page of this exhibit, please? Tell us what we see here.
This is 2 pictures of that 6A bullet jacket fragment after the examination preparation. So the top photo is going to be the interior of 6A, and then the bottom photo is the exterior of 6A.
Now, after you took these photographs, did you proceed to do something to determine whether you had either class, individual, or subclass characteristics?
Yes.
Tell the court what that means.
To start, when I do my initial examination of a bullet jacket fragment like this, I'm going to look at its class characteristics. Class characteristics are the least restrictive set of characteristics I use in my comparison process. And these are design features that are given to a large group of items that characterize them together. So for a bullet, you could think of the diameter of the bullet, the number of landing grooves, the direction of twist, and the type of rifling. So I would go through and look at the class characteristics of this bullet jacket fragment, which was 6 right conventional rifling. Then I'd move on to look at any subclass characteristics. And subclass characteristics are more restricted than class, but less than individual. And they are design features that can be put on an object during the manufacturing process, which is consistent among items that are made by a tool that's in a specific state of wear. So what I mean by that is it's going to be a subset of a larger group, which is why it's not used for identification or comparison purposes for the basis of a conclusion. But when you think of something that's made through a mold process, when that mold comes together, it creates a seam line, and that seam line is going to be represented on all the items that it makes. So that's why you can't use it for the identification process, because it's going to be on a lot of items, which is why it's a subset of the group. Then I move on and looking at the individual characteristics. And these are imperfections and irregularities that arise from the manufacturing process. And then there's also individual characteristics can arise from wear, use, and abuse of a tool. And these individual characteristics is what is going to be distinct to that tool, and that's why they're used for the identification process. So again, I did an examination of its class characteristics, look for any subclass characteristics, and then look to see if there was individual characteristics and the land and groove impressions sufficient enough of marks and values to do a comparison process.
Now, once you have the class characteristics of a bullet, can you narrow the range of firearms that could have fired it just based on class characteristics?
You can, yes.
And is caliber a class characteristic or an individual or a subclass characteristic?
It's going to be a class characteristic because a lot of firearms will have the same class, or excuse me, the same caliber.
Did you measure the diameter of the bullet?
I did, yes.
And did you end up with a range where it could have been a certain range of length or diameter?
I did, yes.
And what was your reading?
Can I refer to my notes,
Yes,
please?
please.
Fragment was 0.286 to 0.301 inches.
Okay, what page are you looking at?
It's page 13.
Okay. Now, so this is your documentation of the diameter measurement. And then on the right there, LIMP, that's measurement of the land width,
The
correct?
land impression width, yes.
And these are all general characteristics, or class characteristics, right?
Correct.
Okay. Now, once you had that this, and also that it was, you said, what's called the rifling was to the right, correct?
The direction of twist, yes.
Yeah, the lingo is 6 to the right, meaning,
6 right,
yeah.
yes.
And that's a class characteristic.
Correct.
So once you had the diameter of the base of the bullet, and did you have some difficulty because of the damage to the bullet in exactly measuring it?
The reason I provided a range was because of the damage and deformity to the base. So at times it wasn't a perfect circle. So it was important to me to give a range of what those diameter measurements were.
Once you have the diameter and the rifling characteristics and the land and groove measurements, can you then plug those measurements into a database and to narrow down the class of weapons from which this bullet could have been fired?
The general rifling characteristics search will use those class characteristics and will generate a list of possible firearms that could have fired the bullet. But that list is not all inclusive. It is just used as an investigative tool.
Sure. Could you go to page 47, please? Could you tell us what we're looking at here?
This is the results of that general rifling characteristic, or the GRC search.
All right, and what did you determine in terms of, just based on the class characteristics, what weapons could have fired the 6A bullet?
There were several different .30 caliber class firearms that could have fired the bullet.
And they're listed here, correct?
Correct.
Could you tell us what the initials PI and RI and PR mean in the far right-hand column?
They refer to different types of firearms, so rifles, revolvers, machine guns, any type of firearm.
And what are the pistol ones? How is that designated? PI or?
Correct.
And what is RB?
Bolt action.
Bolt action. So based on the class characteristics, any of these weapons could have fired that bullet?
They could have possibly fired the bullet jacket fragment, yes.
Okay. Now, let's go back to the examination of the other two measures, subclass characteristics and individual characteristics. Is one of the reasons you look at subclass characteristics because they can be confused with individual characteristics.
That is a concern, yes.
In fact, your manual says that, right? It's important to rule in or out subclass characteristics to avoid the danger of confusing them with individual characteristics.
I'm not sure if our manual says it verbatim. It says that we do need to assess every piece of evidence for possible subclass characteristics.
And what is the reason for that?
Subclass characteristics can be similar to individual characteristics. However, trained examiners are able to notice the difference between subclass and individual. Subclass characteristics are not always present on an item. It's possible, but not always present. And they tend to look a certain way. They're going to be uniform in their appearance. They're going to be spaced in a way that's more uniform. If you think of circles, those circles could be a distance between each other in the same distance every time, and they will look almost the exact same every time.
Now, does your laboratory have certain protocols for conducting these comparisons?
We have procedures for comparison, yes, like taking photographs, yes.
Well, but also procedures for instance, you have a document called Examination and Comparison of Unfired and Fired Ammunition and Components that deals specifically with the procedures to be followed for the kind of examination you did here, correct?
Yes, I believe that refers to the minimal documentation necessary for a piece of evidence.
And one of those standard operating procedure requirements is document observations and evaluate for the potential of subclass characteristics on the relevant tool working surface, right?
Correct, yes.
And you did that in this case, correct?
I did, yes.
Okay. And what conclusions did you reach?
Can I refer to my notes?
Yes, please.
It states, stria observed in the land and groove impressions contain starts and stops, are not coarse, and vary in their height, width, depth, and spatial arrangement. No apparent subclass influence.
Okay. And what page was that again?
Page 13.
Page 13. Well, let me ask you about that. Not coarse, I think I understand that. And vary in their height, width, depth, and spatial arrangement. Did you measure the height, width, depth of the land and groove impressions?
The land and groove impression widths, yes, I did.
And how about the striae? That's different than the land and groove impression, right?
Correct, yes.
You didn't measure the height, width, and depth of those marks, correct?
No, I did not.
Okay. And your protocol says, does it not, due to their similarity to and potential confusion with individual characteristics, it is essential that the evidence be evaluated for the potential of subclass characteristics.
It does, yes.
That's the whole purpose of why you're doing that part of the exam, right?
Correct, yes.
And anywhere in your protocols, does it specify what you're looking for, or is it just up to you to decide what is and what is not a subclass characteristic?
Subclass characteristics are a very large part of the training process to become a firearm and tool mark examiner. There are modules that are taught where you're trained to recognize what subclass characteristics look like, what manufacturing techniques might lend to more subclass characteristics. So I am trained to know what it looks like.
Okay, and my question though was, does your standard operating procedure set out, here are the things you should be looking for for instance, does it say if what the marks you're looking at are not coarse and vary in their height, weight, depth, and spatial arrangement, or if they're perpendicular on the barrel, that indicates that it's not a subclass characteristic? Is there anything like that in the manual?
No, there's not.
Okay. Did you inspect the interior of this barrel?
I did, yes.
And did you notice whether it had any debris or dust in it?
I believe my notes state that debris and dust was observed in the inside of the barrel, yes.
Okay, and could you further characterize what that was? Debris,
I think it says dust, so I would say dust.
dust. What can cause dust to get inside of a barrel?
A plethora of things. I'm not sure why something is ever in a barrel.
Okay. So you determined here, you ruled out subclass characteristics, correct?
Yes,
Then the next part of the examination was determining whether you had any individual characteristics on the bullet, correct?
yes.
And what did you conclude in that regard?
That there were microscopic marks of value worthy of comparison or, yes, individual characteristics in the landing group impressions.
And does your standard operating procedure have any guidance in terms of how you go about determining that?
No, I do not believe so.
Okay. And then once you determine that you have items of value on the question bullet, do you then do something to produce test bullets?
Yes, part of the comparison process when there is a firearm that we receive is to test fire it to make pristine samples to see if reproducible individual marks of value is on the bullet or the cartridge cases.
How many test fires did you produce in this case?
I made 3 sets, so 6 total.
Is that your standard number of test fires?
Our standard operating procedures state that you need at least 2. There is not a maximum number that we are allowed to do. It's the discretion of the examiner.
Were you informed by other investigators working on the case that this particular weapon was manufactured in Germany in 1938?
I was not, no.
You did not review a report from an ATF agent who investigated that issue?
No, I don't believe so, no.
In doing your examinations, is it important to know something about the manufacturing process of the weapon?
It is helpful to know how a barrel or any part of the firearm is manufactured, yes.
And why is that?
Certain manufacturing techniques will lend to that individual characteristics. So grinding is a method that is known to leave individual characteristics on a tool. So if a item that I receive, I can tell.
Oh, I'm muted. Oh, okay. So he mentioned that this particular brand was manufactured in Germany in the 30s, which is interesting. However, I don't think, based on the look of that particular firearm, there is a difference between. Oh, Michael Burt, we need to have conversation on gun manufacturing. And YouTube, please don't demonetize me for this. And if you are ever so kind, YouTube has demonetized 3 of these streams. However, the manufacturing process, just because a certain firearm was designed and originally manufactured in a certain country or a certain time period, does not mean that current version is also manufactured or is that old. I have a 1911. It is called a 1911 because generally the design originated in, well, you guessed it, 1911. There's some details to that I'm just not going to get into because it's not relevant. However, just because that design came out of Germany in the 30s does not mean that they still use the same metal and the same alloys that were used in Germany in the 30s. The design might be the same, but the metal has gotten upgrades. The manufacturing process have gotten upgrades in the last 90 years. Are you that fucking stupid where you are trying to make the judge and the world think that this Mauser 98 was 100 years old? I mean, are we really so are we really so crazy? Like, do we understand? I'm trying to turn Flash fan stuff down, but remember, guys, he's on an iPad, and an iPad is just picks up things, and it's just a little bit harder. So shit's dynamic. It is what it is.
I don't know why it's the echo if it is one. I don't know.
I don't know. It doesn't do it all the time too. That's what's weird.
I'm literally
So-
not doing it. I'm literally just sitting there.
That's where I'm like, yeah. Well, it was, yeah. Well, it was his grandpa's gun, but like my grandfather's gun was like doesn't mean that it was the age of my grandfather. like if I were to get one of my uncle's pew-pews right now, he is a little older, but that doesn't mean all his pew-pews are the same age as him. So that gun did not look that old. That gun did not look that old. Maybe 15, 20 years old.
I gotta say, what year was it? 80s or?
Huh?
I said, what year was it? Was it an 80s gun or? I mean,
Well, the gun was originally manufactured in Germany in the 1930s.
Ooh,
And that's what he brought up.
That's a World War II weapon.
Yeah, but that particular firearm is not 90 years old. Just because a certain design was developed in a certain era does not mean they use the same metals. He's making it sound to the layperson as if they're still using the same metals and the same alloys as they did in the 30s to manufacture.
Oh yeah,
Yes.
no. Technology came a long way since then. Technology came a long way since 10 years ago.
Yes, and just because a certain design was designed, like my 1911 was manufactured in 2019. Just because it was designed, like the original design was in 1911, does not mean that the metal that they're using was from 1911. Oh, like my brother-in-law has a Kentucky long rifle. It's not the same metal that was used in the 1800s. It's updated alloys to what modern weaponry is made of. That's another way how you can date things, is what kind of metal they're using, what kind of alloys. It's like he's taking things. Yeah. After the war, millions of those Mausers were imported as surplus in the U.S., retooled as sporterized in 30-06 caliber and hunting purposes. It's, it's just, yeah.
It's finished or manufactured by grinding, it already gives me an indication that individual characteristics would be left from that tool to the tool mark.
Now, once you have your 6 test fires, then you did some comparison between the test fires, right?
That is correct, yes.
And why do you do that?
That establishes whether or not there are individual reproducible marks of value on the test fires. It's important to know that because if there's not reproducibility amongst the test fires, then there's a chance to say, oh, it's not going to reproduce on the evidence and I wouldn't have anything to compare it to.
And have you had cases where you fired the 6 test fires and you don't get reproducible marks?
Not that I can recall.
And when you do your comparisons, just looking at the test fires, do you get situations where there's some dissimilarities between those 2 fired bullets from your test fires?
Yes, there are times there will be disagreement amongst the individual characteristics, even in test fires. You have to think of it as when a bullet travels down a barrel or a cartridge case interacts with a firearm, the marks aren't going to be left onto that item the same way 100% of the time. It's almost like a stamp. If you know you're using a stamp and you put it in ink and then you put it on 2 separate areas of an item, it might look a little different just from the way the stamp was placed. It's the same thing with a bullet traveling down a barrel or a cartridge case coming into contact with a firearm.
So even when you know a bullet is fired from the same weapon, you can have 6 bullets fired, and when you start comparing them, you will see differences between each bullet.
There's a possibility to see some areas of disagreement. However, if I'm rendering an identification and saying there's reproducible individual marks of value on these test fires, there will be an overwhelming amount of sufficient agreement of that individual characteristic.
Now, when you're doing these comparisons, you use something called the AFTE theory of identification, don't you?
Yes, the AFTE theory of identification.
All right, and take a look.
He's
And
not good
that's
with
the
acronyms.
standard that you used in this case to draw the conclusions that you made in the report that I showed you earlier, correct?
That is the theory stating how an examiner is able to come to a conclusion when examining 2 or more sets of tool marks. And yes, that is how I go through my examination and how I come up with my conclusion, yes.
Okay, and what is AFTE?
AFTE is the Association of Firearm and Tool Mark Examiners. It's the governing body of the firearm and tool mark community, whose primary goal is to further research and continue to show information about manufacturing and the evolution of firearm and tool mark examination. They hold annual seminars, publish a glossary of terminologies used by the firearm community, and they also have a peer-reviewed published journal.
Peer-reviewed published journal. Can I join AFTE?
You can. Most of the firearms community, or excuse me, members are firearm and tool mark examiners. There are also technical advisors and associate members. Those members are not usually firearm and tool mark examiners, but they still have a livelihood in firearm and tool mark examination, meaning they conduct research or they are involved in products or manufacturing. And anybody is allowed to come to the annual seminar or get the journal. You just have to pay the fee.
You just have to pay the fee. Okay. Could you display to the witness Exhibit 27, please? Do you recognize what's displayed here?
It appears to be the AFTE theory of identification, yes.
I move that into evidence, Your Honor.
What is it?
This is the standard that she used to make the comparisons in this case, correct?
Would this be Carner 27
This would be Carner 27, Your Honor.
for the state?
Your Honor, if I may order the witness on this exhibit, I've never seen it before, I don't think.
All right,
Sure.
let's go ahead and do so, Mr. McBride.
When was the last time you reviewed this document?
I'm not sure off the top of my head.
Can you testify as to its accuracy by looking at it now?
Not verbatim, no.
Your Honor, no more questions. My objection is lack of foundation.
Mr. Bird.
Short and sweet.
Does this document accurately state what the theory is?
May I take a moment to read through
Yeah,
it?
sure.
Yeah, and I'm sure it would look like it was pre-World War II. I'm standing up. Oh, welcome to my, there we go.
Been sitting too long.
Oh, my back is, my butt
I believe
killing me.
something, I think the first statement is different than what I can recall, but overall, it is what the AFTE theory states.
Okay. And your ATF protocol refers specifically to the AFTE theory of identification, does it not?
It does, yes.
Okay. So is there any difference between what's in 27 and what's in your manual?
Again, I don't remember without looking at them side by side.
Okay. Let me get that in front of you. Let's go to,
And I'm not sure if the defense is purposely being shady or they're just being stupid. Because if someone who doesn't know what the hell they're talking
12.
about, and I'm not an expert by any means, I need Mr. Squid's opinion on that, but
and go
someone who doesn't
to
understand what they're
theory
talking
of
about is asking
identification and range of
questions, it
conclusions.
also becomes weird.
Page
Maybe it's
103. I
both.
don't have a base on it. It's toward the end.
True.
It's document
mean-
FT 10. Can I put you in the front?
You may.
I recognize this as something that comes from our SOPs, yes.
Okay. And it refers to the AFTE theory of identification, right?
It does, yes.
Same theory that's displayed in 27?
Yes.
Okay, so I'd renew my offer on 27.
Your Honor, the objection stands. Language matters. Without knowing what, if this language is identical to what she's trained on, that can make a big difference. Whether the word sufficient or adequate is used, these are scientific principles, and we need to be precise in the language that's used. The witness cannot authenticate the exhibit that's been offered, so it should not be received into evidence.
He go overrule it.
Goes to weight, not admissibility, he'd be free to question her about any differences, but I think she's laid a foundation that the theory is the same, so.
All right. Well, I remind the parties that this is a probable cause finding, and so as it relates to what's been presented, the witness has said that it looks familiar. Again, I don't want to quote you, I don't remember the exact phrase, but she recognized portions of it and then was given the opportunity to compare it to her
See, it's kind of
standard
like
operating procedure, I think she
the
said.
graph is like, well, I'm going to overrule it, but I just remind you that this is probable cause. You got to stop saying it and actually be like, okay,
Grow a
I
pair.
told you this is probable cause. So,
Grow a hair.
gee, this is what I thought I liked him, but he's starting to irritate me with this now.
Act like you have a pair and act like Kathy Nestor didn't put them on her shelf.
SOP. For those reasons, Carner 27
Yes,
is admitted and may be
Okay.
published.
That's why they can get away with all this stuff.
Yeah.
looking at the language of this, the second part of it, according to AFTE, says currently the interpretation of individualization, identification is subjective in nature. Do you agree with that?
Yes.
Why is it subjective in nature,
The conclusions that I author are of my opinion.
of your opinion?
Correct.
Does your, you can take that down, thank you. And no, wait a minute, go back if you would. But while he's doing that, does your manual state, what you're looking for under this theory is correspondence of individual characteristics?
Yes.
That the theory is that if you see a certain level of correspondence, you can make a source identification, but not to the exclusion of all other firearms in the world, correct?
Correct.
Okay. And the standard, at least as it's articulated here, is the theory as it pertains to the comparison enables opinions of common origin to be made when the unique surface contours of two marks are, quote, in sufficient agreement. And is a subjective part of that, the quoted part, sufficient agreement?
The subjective part of the conclusion is saying, yes, it is my opinion that there is or is not sufficient agreement or sufficient disagreement amongst two or more tool marks.
And what may constitute sufficient for you may be completely different from the next examiner. Fair?
Yes and no. I would expect any trained, competent examiner to come to the same conclusion. So the threshold of sufficient agreement might be different from one examiner, but the conclusion I would expect to be the same.
Does your manual state, your ATF manual, section 431, state that correspondence or lack thereof of individual characteristics is not easily communicated? An observation such as significant agreement can mean different things to each examiner. This does not serve as interpretable descriptions of what was observed because the individual performing the review will likely have his or her own concept of the phrase based upon their training, experience, and knowledge.
Objection, Your Honor. This question goes to weight. Oh, I'm sorry. You don't. Maybe heard.
If you're objecting, I will hear the objection.
Just speaking objection. That's why I stopped myself. This goes to weight. This goes to
I
credibility.
absolutely am following what
and
you're talking about, Judge.
the witness's report has already been admitted as is appropriate under the Utah Constitution, Rule 7B and Rule 1102 of the Rules of Evidence. This is beyond the scope of preliminary hearing for those reasons.
Mr. Burns.
Number one, that's a general objection, which I think has been waived. The state was privy to the interview with this, pre-hearing interview with this witness where the same questions were asked.
Yeah, you should waive
We
your
had a
objection.
scheduled hearing where the court was going to rule on objections. The state indicated in advance of that
really?
hearing that it had no objections
You're a
to
hypocrite.
the testimony, reserving the right to make particular objections. But the
He's a
objection being made
hypocrite.
is a global one. And it's relevant because the state offered, the evidence I'm offering here is relevant because the state offered through a hearsay declarant the meaning of this report that this examiner authored. And I'm trying to inform the court on what the limitations are of the opinions expressed in the report that the state offered. And it's certainly relevant to the reliability issue to know that the opinion is based on a subjective standard that the witness herself admits is subjective. So I think it helps the court understand what weight, if any, to give to this report that the state offers.
All right. Mr. McBride, final thought.
That's all fine, but it's inviting the court to weigh the evidence. That's the whole point. And at this point, the inferences are drawn in the state's favor, and the court is not to weigh even contrary
He
evidence.
talks about
Well, in regards to whether objections have been waived or not, the court as a magistrate bears the ultimate responsibility to ensuring that this hearing is a probable cause standard. And so that's a responsibility that as a magistrate I take seriously. I understand the arguments from the parties. I'm going to overrule the objection, but Mr. Burt, this is, we don't need to go 100 miles down a path where 1 mile is where probable cause may be. What you,
you need to
question
stop
done.
changing the objection.
thank you,
That-
Mr. Burt.
It's a 12-page.
I usually just listen and watch for Squid to snap on
Just a-
people. Yeah, Squid is at that point.
That happened 4 days ago.
Yeah. I done snapped 4 days ago. Now it's just unhinged.
You may.
People's or state 32.
People's Republic of California,
If you
that's
go-
what he was trying to say.
To the second page, please.
Yes, the master. They kept talking about, we've already had evidentiary hearing, yet
You
y'all
concluded here, did you
objected
not, that
they
the
ever-
exhibit 6A bullet jacket fragment could not be identified or excluded as having been
or
fired
he
from the
forgets
exhibit
that word or excluded.
1A based on an
excluded.
agreement of all discernible class characteristics and neither sufficient agreement nor sufficient disagreement of individual characteristics. The result of the comparison was inconclusive.
Yes.
That was your ultimate
Use
conclusion,
double
right?
standards.
And on the next page, if you could go to
Double standards.
2 pages in,
So I respect
you have an appendix, do you not, where you explain what inconclusive means? Next page, one more.
You're
There we go.
arguing against yourself.
I want to ask you because I'm
guy's
unclear on what
trying to make
inconclusive mean. You say reasons for an inconclusive or include the presence of microscopic similarity that is insufficient to form the conclusion of source identification, a lack of any observed microscopic similarity, or a microscopic similarity that is insufficient to form the conclusion of source exclusion. Could you specify which of those possibilities exists in this case? Was this a case where you had microscopic dissimilarity, but in your opinion, it was insufficient to form a conclusion of source exclusion?
No, my conclusion is inconclusive, just as it says in the appendix. There's a lack of sufficient agreement and sufficient disagreement, so I'm unable to say one way or another.
Okay, but I guess my question is, were there points of dissimilarity between the question and the known bullets?
Again, there was sufficient agreement and there was not sufficient agreement or sufficient disagreement. So yes, there was times that I saw agreement in the striations and the land and group impressions, also seeing disagreement, but there was also a lot of lack of microscopic marks of value to see it all. So because of this lack of quality and quantity of marks to be able to see, it never reached the threshold of sufficient agreement nor sufficient disagreement. So an identification or exclusion could not be rendered.
Okay, I think you and I met before today, correct?
Yes,
Where we talked about what that term inconclusive meant, correct?
yes.
And I think, and correct me if I'm wrong,
Please
But-
correct him.
did I read to you from a,
I would have loved to heard that conversation. Just general conversation.
do you recall me asking you whether you agreed with this statement, that an inconclusive conclusion indicates that the microscopic marks in question may or may not have originated from the same or known source?
I do remember you asking, yes.
And you agreed that that was a correct definition of what you concluded in this case, correct?
Correct, yes.
Okay, so I want to, if I could, return to 10, Exhibit 10. And in Exhibit 10, not 10, I'm sorry, your case file again. This is, you have produced for us some nice
Yes, looking for pages.
comparison photos of your comparisons, correct?
Yes.
Okay. And if you would go to on the left and another test fire from the same gun on the right.
Yes, it is.
So do you see areas of agreement and areas of disagreement in these two bullets fired from the same rifle?
I see sufficient agreement amongst the striations that are in this land impression.
Okay, and tell us where they are. When you draw that conclusion, using
I
this
love it.
subjective theory of identification, show us what you're looking at.
Is it touchscreen?
Probably, no, it's not.
No,
I'm sorry.
but we can, if you direct us, we can get there with a pointer.
Sure. So you can see towards maybe the last third of the bullet or the land impression that, yes, right where your cursor is below there, that's an area of agreement with that striation. It looks like it's going from the left to the right. So that mark is appearing on the test fire on the left and the test fire on the right. Then if you look towards the top of that land impression, there's going to be some more lighter colored striations or lines that are moving from left to right. Those areas are in agreement as well.
Where is that? Not as far up as where he is, correct? It's down?
Yes, and I believe the PowerPoint that I provided does have some areas and circles of some of these marks, if that would help as well. But if you move your cursor up, continually up, keep going. There you go. You have a line that was right there, and you have several others underneath of it that looks like it's going just straight across from left to right, and that shows an observed area of agreement.
So that one he's got circled on the right, I see a line there. Are you saying you see a line on the left that it's identical to the one on the right?
I'm saying I see agreement amongst those striations, yes.
Okay, anything other than those two areas?
You can really go down the entirety almost of that line looking at those striations. So under the top red circle, there's another area there. Yep, if you start right there and you draw your circle over, like I said, at the top of the circle, there's a highlighted line.
I'm not gonna lie, I thought that was the same bullet. But I thought that was one and the same.
Oh, it's a
Okay.
different one.
Yeah, that's the one on the right is the fragment that came
Oh.
from Charlie Kirk's body. The one on the left was the test fired.
Okay.
So I'm not gonna lie, I thought they were complete. I thought that was one,
One and the same.
yeah, until you actually look at it and you realize it's two separate pieces and she's comparing the two.
On the left that goes all the way to the right. If you go a little bit farther down, maybe still in the top third of that circle, you can see another line going from one side to the other, another area of agreement as well. And then under the final third circle, in a little darker area down there, there's still some lines, again, in sufficient agreement.
Okay, and again, these are comparisons between test fires. So you know the rifle that you're test firing fired these two bullets, right?
Yes, and the purpose of those test fires is to ensure that though it was smart, it
Both
was
test fires.
fired from the same firearm. You want to make sure that those individual characteristics are reproducing.
All right, so go to the photo on the bottom of that page.
Okay, there
This
you
is the
go.
first of several comparisons between the test fire on the left and 6A on the right, correct?
Yes.
And what does the writing on the top mean, blue index GIMP?
So that will be the first
Don't know for sure. We haven't actually seen the autopsy report, so we don't know for sure. This guy obviously thinks that rifling impressions on a fired bullet stays intact upon impact with things such as bone. Yeah, I know, right? They fragment and become all screwed up, and it's not like a sample from being fired. Yeah, and we got to think like this is a 45. This is much smaller in comparison to what was fired from a 30-06. Obviously, there's a size difference. So don't quote don't kill, don't shoot the messenger here, but um this is just what is this is just what lives at my desk. And that which matches Linda, which is locked right here. Just in case anybody decides to break into my house while I am streaming. Have a nice day. I'm
You
just
gonna be
saying.
like you gonna be like
So
another
this is
David
just what
Byron Smith.
lives, huh?
You gonna be like another David Byron Smith, a dude in Missouri or Minnesota who decided to lure people because they were breaking in the cops didn't do nothing. He lured them in his
No,
basement.
I'm not luring anybody there here. I am just protecting the fact that I have a 3-year-old and I stay at home most of the time by myself and my 3-year-old. And I am not the type of person to be an easy target, so to speak. But this is just what lives at my desk. She stays here with me. She's my side chick. However, think about this not only being fired. So this projectile coming out, this casing, so you got right there, just the end, being broken up into multiple pieces, going through human tissue, hitting bone, being ricocheted off bone, breaking apart even more. Things are not pristine. Bullet analysis is not an exact science. It is not a definite, just because it's inconclusive does not mean, oh my God, he didn't do it. And remember, like we talked about yesterday, one of the things that I think people, and especially lawyers, fail to realize or fail to take into consideration, and even prosecutors fail to stress to juries, is when fragments go through a human body and hit bone, and then that person tries to be revived and saved by medical personnel. Medical personnel are not concerned with preserving evidence.
Yeah, nope.
They are concerned with saving a life. So now you have surgical instruments that are also interfering with the possible quality and contamination of these fragments as well. So you might have tool marks from scalpels because doctors are not concerned with preserving evidence. That's not their job.
It's like some case I was watching, and the paramedic was testifying, and it might have been a staircase thing. I watched a few episodes of that, and it was like, "Well, you didn't preserve this, or you didn't take this." She's like, "I am a paramedic, sir."
Hey, buffed old man, how are you? Good to see you. It's just one of those, like, they also fail to take into account that when doctors are trying to actively, and I don't know how far into the hospital he made it, if they actually got him into surgery and tried to
What
save
was he
his life.
actually taken to emergency the hospital?
Yeah, he was taken to the hospital in the vehicle of one of his team member, or one of his
Security.
team members. However, I don't know. And also you have people when they are doing life-saving measures on scene, basically sticking their hand in the wound to stop the bleeding. So you
Yeah.
also have people interfering with possible evidence trying to save a life.
Yeah.
And those are facts that I don't think are stressed enough by even prosecutors, that evidence can be tampered with unintentionally by
Yeah,
life-saving measures.
in front of a jury, the defense is usually like, well, the crime scene was compromised and tampered with, and the state is somebody trying to disprove it. I'd be like, well, okay, you can't protect it all the time. If somebody trying to save somebody's life, then okay,
Yeah,
yeah. It's gonna be
life-saving first, protecting a crime scene second. If someone's been unalived and been laying there for, , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , , enacted. So
Yeah,
you could prove the
not
crime.
like that not like the other case, that foreign case I'm watching where the crime scene investigators or the detectives didn't arrive till like 5 hours after the crime. I'm like, yeah, that's a problem.
Yeah, when someone is still technically alive, um, you have medical personnel, you have people sticking their hand inside of his neck to put things back together and hold arteries together
To
to
keep her from
stop the
bleeding
bleeding
out.
long enough
Yeah.
to get yeah. Yeah, and that see, CPR to me is one of those, like
I think it was you that told me that CPR shouldn't be trusted.
well, no, it's not that CPR shouldn't be trusted, it's where his injury was, you're never gonna get oxygen to the brain because the artery that brings oxygen to the brain was severed.
Oh wow.
So, basically, every time that you're pumping the heart to put and basically manually pumping the heart, you're pumping blood out of that artery.
Yeesh.
So, it's like yes, it needs to be done, but at the same point, it's potentially making the bleeding worse, which is one of the reasons that that's so fatal. Yeah. Yes, life-saving measures are viable, the life is more important. I don't think even prosecutors, um, but I don't think that's stressed enough to the jury that, "Hey, the reason why this evidence is also more damaged than normal is it hid bone, but it also has tool marks on it, potentially from surgical instruments, when they were trying to remove them and save his life." So, it's just it's one other consideration to take into account when you're talking about damage to bullet fragments. It's just an interesting from a medical my brain goes to medical side, what to look at.
You would make a good
Number there
expert
is
witness in one of these cases.
Huh?
You would make a good expert witnesses in one of these cases.
No, because 'cause I'm not an expert at anything. However, it's just one of those considerations that my brain goes to, well, what about the tool marks? What about how far did he make it into surgery when those bullet fragments were removed? Who removed them? Were they removed post-mortem by the medical examiner who actually cares about preserving evidence? Or were they removed in surgery by a, trauma surgeon to save his life? Because there is a difference. There's it's all about the perspective of the person doing the work. Trauma surgeon, save life, does not care about evidence.
Yeah.
Medical examiner, still a doctor, cares about preserving the evidence, generally done post-mortem, has a
Yeah.
little more leeway with destroying tissue around the body because he's not trying to preserve a life. He's trying to preserve evidence.
Yeah.
Trauma surgeon does not care about evidence.
Yeah, that's not their role. That's investigators and coroners and stuff like that.
Oh yeah, and I don't think honestly, as soon as I saw the shot, I looked at Mr. Squid and I'm like, look at this. He's dead. Like he's dead. Like I was surprised he was alive before he hit the ground. I thought he was dead before he hit the ground.
But you see cases where it's extraordinary sometimes, but you see cases where victims survive and shots to the head. So anything's possible.
Yeah, I just looked at that and I'm like, where that hit, like it. Yeah, those bullet fragments could have traveled all over his body, not just in his neck and his head. Because you could say you shoot right here. If you hit, even you sever the windpipe, and you hit the it's the hyoid bone. You could go down into his esophagus. Like you could have bone fragments in his digestive tract because of where that may have entered. Or if it hit the collarbone, it could go down and straight into the heart, which very may well have happened too. We haven't seen the autopsy report. We don't know. But these are just like when you're talking this area, there's lots of things here that, you know, Not particularly. Yeah. Yeah, and that's where it's like it's one of those details that we don't know, but it's speculation, and that's why I say I don't know how far he got in surgery, so I can't say that any marks on the fragments were done by trauma surgeons. However,
But I was under the impression that
it's
it was
just one of
instant.
those it's just one of those things to keep in mind, not just for this case, but for all ballistics cases, that when you're talking about fragments from a bullet being deformed, that it could potentially be medical personnel who
Maybe I should read that book, Forensics for Dummies.
I mean, all right, let's get into this.
The case number, the laboratory case number. Then next 1.11b is going to refer to the specific test fire that's on the picture. And then V versus 6A, so that's the evidence that's also pictured. GIMP stands for a groove impression, so I'm looking at a groove impression in this photo. Blue index means I'm specifically looking at the groove impression that I have put a blue indexing mark on so that I know where I am during the comparison process.
Okay.
30X refers to the magnification that the photo was taken at, and then INC refers to inconclusive, the final conclusion.
So I'm interested in the areas of disagreement. Are there areas of disagreement between the known and the unknown here that you could point us to?
So for this photo, to me, I see areas of agreement in the top. And then on the way down from the 6A, right after you see those two highlighted lines near the top, there's a lot of damage that is observed, and almost no microscopic marks of value can be observed at all. So again, that lends to the lack of quality and quantity of marks even to do a comparison. It's almost like missing data points.
Okay, missing is not the same thing as dissimilar though, right?
It just means there's nothing there to call agreement or disagreement.
So do you see areas of disagreement here or no?
On the striations that are available to me on this groove impression, I see areas of agreement, and specifically talking about those two highlighted lines at the top on the right.
Okay, go to the next page, please. Top photo on the next page. It's B38.
Photograph that we looked at before, just at a different magnification. It's zoomed in a little bit more from 30 to 40x. So again, I'm looking at those two highlighted lines near the top. And then if you look down, you can almost see that damage a little bit better. And there's none of those striated lines that you see on the test fire, which you would expect to see in a lander groove impression on the right at all. So again, no microscopic marks of value to compare whatsoever.
All right, how about the bottom photo?
Does not look like it carries over, but just from this snapshot, I cannot say if I had moved the photo a little bit different or the specimens together, that area would be agreement. In this photo, it does not look like it does, though.
Okay. And could you go to the next photo, please?
The way this photo was taken is highlighting more of the lack of microscopic marks of value. If I had pulled the specimen that's on the left, the test fire over, there might be some agreement that could be observed, but the way the photograph is now, you don't see the line on the right going all the way over. But again, this is just a snapshot of one particular area.
Doesn't show areas of agreement or disagreement?
There is an area of agreement at the very bottom of the photo.
I agree with this comment 100%.
Okay.
Correct, yes.
100%.
Next photo, please. How about this one?
This is another zoomed in of the previous photo, focusing in on that bottom area of agreement. So we went from 30x to 40x and just highlighting one specific area, and this is showing you agreement.
Next photo.
So again, this area that is highlighted, the bottom portion that's in focus, is showing an area of agreement. As you go up, the lines are a little bit blurred on the 6A bullet jacket fragment, so it's hard to say if that area was an agreement or disagreement. That's not what my photo was focusing on.
All right. Next one.
Is going to show you part of the groove impression at the white index. On the top, you can see some striated lines, or excuse me, more of the middle of the photo. The top of the groove impression from the 6A, you see some lines that do not appear to be on the right side either, but this photo is also trying to show the lack of microscopic marks at all towards the bottom of that groove impression.
Okay. But there are in these photos areas of disagreement as well as areas of agreement, correct?
In the photo that we just looked at, it could be possible areas of disagreement. Again, it's just one area that I'm looking at. It's hard to tell when you can't look at the entirety of the land in this moment.
Now this, you can take that down, please. Do you keep up with the literature relevant, scientific literature relevant to your field?
I do, yes.
And are you aware of certain criticisms that have been leveled against this AFTE theory of identification?
I have heard, yes, I've heard recommendations on how to improve the AFTE theory of identification, yes.
Well, the criticism have gone beyond that, right?
Specifically, what are you referring to?
Well, you're aware that the National Resource, the National Resource Council?
The National Academy of Science?
National Academy of Science?
Yes.
Is that a pretty preeminent scientific organization in this country?
Yes.
Did they conclude in 2009 that, quote, a fundamental problem with tool mark and firearm analysis is the lack of a precisely defined process? As noted above, AFTI has adopted a theory of identification, but it does not provide a specific protocol. It says that an examiner may offer an opinion that a specific tool or firearm was the source of a specific set of tool marks or a bullet striation pattern when, quote, sufficient agreement exists in the pattern of two sets of marks. It defines agreement as significant when it exceeds the best agreement demonstrated between tool marks known to have been produced by different tools and is consistent with the agreement demonstrated by tool marks known to have been produced by the same tool. The meaning of exceeds the best agreement and consistent with are not specified, and the examiner is expected to draw on his or her own experience. This AFTI document, which is the best guidance available for the field of tool mark identification, does not even consider, let alone address, questions regarding variability, reliability, repeatability, or the number of correlations needed to achieve a given degree of confidence.
I do remember
Objection.
this.
Objection. We're now firmly into 702 territory. I object on grounds of relevance to the probable cause hearing beyond the scope of the PC hearing, as I previously objected.
This
I think
is
a group studied this exact process. That
He's going to overrule it probably. but-
this is trial or evidentiary hearing and
Yeah,
admissibility.
He's trying to destroy her credibility, but that doesn't matter.
This right here, all of this grandstanding is for the media. This has nothing to do with actually what's going on in this. This bullshit is for the media and the headlines to get positive press for them, to make up for everything that happened earlier in this day and the rest of the week.
He's like, they won't listen to me. I was on national television. I was in one of the first biggest trials in the world.
Yeah, this is all about positive press for their client and discounting the prosecution. This has nothing to do with probable cause. But the judge is gonna, oh well, hee haw, like fucking Eeyore.
He's gonna be like,
Used in this
well,
case.
just remember it's probable cause, but I'm gonna overrule the objection.
No, instead of it's probable cause, shut the fuck up. Like it's probable cause, shut up, sit down.
reach that conclusion.
If you would, so deep in regards to it, this is citing to 2009. And so we're in 2026. And again, I don't want to have to dive deep into orbit
I don't
of
wanna have to
probable
tell you how to do
cause.
your
If
job,
I'm
I
having
won't
to
tell you to do your
make
job.
that analysis and trying to see, like, how is this relevant? How does this apply? How does this go to probable cause? So if you wish to ask this question and then move on, we certainly could do that.
And I know when we had raised this issue with respect to one of the other experts, the comeback was, oh, well, this was in 2009 and the PCAST report was in 2016. In this particular field, these criticisms have started in 2009, but they have continued up to the present day and have gotten more strident. So I think that's the
Not
take
just
home here, is
family.
that this is not some past criticism that has been set aside. This is a criticism that this expert is aware of and that has continued in the literature up to the present time.
But I don't have that second portion of what you just said in front of me. So I can't agree with you because what I have is what's before me. I can't go searching myself as a magistrate for probable cause. I have to take what you say as it is. And if I have to start searching, I've left the universe of probable cause.
I agree. And I
That's the very definition of if it's not in the docket or you didn't present it to me in oral arguments, I don't know. That is the very definition of the judge cannot do his own research. And when I hear people say, well, the judge should research the defendant or the clients, that's not how that shit works.
That's his job. He's impartial. This isn't
That's-
a country where a judge is the trier of fact neither. His
Yeah,
job
that's
is
not how it's like that's not how this shit works. And that right there is a perfect example of that's not how this shit works.
I was offering that to the court as a proffer in terms of where this line of questioning is going, so the court can understand the context.
Okay.
It isn't just an isolated criticism, and I'll establish with a couple of questions that it's continued up to the present time.
So I will overrule the objection, but you're outside of probable cause. So we have to.
And you're also aware of the criticism leveled in
You're
20.
outside. I will overrule it, but you're outside of probable cause. That's not overruling it. That's sustaining it, sir. I'm not trying to tell you how to do your job, but
It's like he's afraid to sustain it. I mean, he's overruling, but it's like he.
I think it's part of him. I think it's part of him being new, and this goes to Belitho as well in the what the hell's fucking shit show. Is he's new, and I think they're scared.
He's only been on the
be-
bench since May 2025. So
Yeah, I think when newer judges are scared to be stern and put their foot down because I think they're so scared of attorneys that have more experience than they do. I also think they're scared of being
like a Michael Burt who has
people
40
going over their heads and their appeal decisions. I don't agree with it, but I think that's the because I see this is not the only judge that does it. Belatho does it. I hate it there too. I'm trying to see the psychology behind it. Is I think they're freaking scared.
Somebody said this reminds me of the OJ trial. This is OJ trial stupidity. Is the OJ lawyers were stupid.
Yeah, you can say it. He's weak sauce. Yeah, I just wish I've already said it. He needs to grow a pair or ask Kathy Nestor for his balls back.
Yeah, nah, this guy, he started out as my favorite, but I don't know anymore because he doesn't
put his foot down for anybody. And sometimes I feel like he needs to put his foot down for the prosecution too. However, this case, I feel like the prosecution is being more like you even heard the prosecutor say, well, you don't like, or you said no speaking objections, so I'm reserving myself. Like I caught myself. Whereas the freaking defense is like, blah, 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 blah,
they don't care. They don't even apologize for it. They just go ahead and make
they just do what they want. Because they know that they can walk all over him, and that's the problem.
16.
Counsel, I just said that we're focused solely on, I've accepted what you've said, but I said it's limited to this question and then we're moving on because anything further is going outside of probable cause.
I misunderstood. I apologize to the court.
I apologize if I wasn't clear on that. So maybe it was my error not communicating.
No, it wasn't your
I've
error.
accepted that.
He's trying to circumvent. It wasn't your error, Judge Graff. No.
And he ruined it. He just had me. I'm like, finally, round of applause. Then he ruined it.
It wasn't. Don't apologize, Judge. He knew what you meant. He just didn't fucking care and wanted to do it anyway.
Coming in, I've overruled the objection, but I said we're gonna leave that where it is and then move forward.
And that's where I'm unclear. When the court says move forward, no more questions about any further criticisms beyond that one?
On this line of question, that's correct.
Okay.
Thank you,
Right.
Mr. Burt.
And I think I've made the proffer in terms of the relevancy of it.
And I accept that. So thank you, Mr. Burt.
All right. Then the last area is in the years that you've been doing this testing, is it true that you've only taken one proficiency test that involves bullet comparisons?
Yes, I've only had the opportunity to take one bullet proficiency test so far.
And is it true that that was in 2023?
I don't remember the exact year, but that sounds correct, yes.
Right. And is it true that that proficiency test involved a test where you had question bullets and then you had two sets of bullets, one that was fired from one gun, not the suspect gun, and then a second gun that was fired from another gun?
I don't remember the exact final ground truth answers that were there. No, I'm sorry, I don't remember.
It was 2023.
When you and I talked about this, you
know
said
how much work she's done since 2023? It was like, hey, when Joint Commission came to see you in 2017, what answers did you give when they asked you about your scheduling procedures? I don't fucking know.
I would have gave my honest response. So every time I'd be messing around like, do you remember what you did in 1999? So like, I barely remember what I had for dinner last night.
Yeah, I had to think. I don't even know what I had for. No, I didn't have breakfast yesterday. Well, wait. Yeah, I did have breakfast. See what I mean? I can't remember what I had for breakfast yesterday. You really think I remember a test I took in 2023? No.
Aware of a controversy about that particular test, correct?
I was aware, yes, of the results of the proficiency test, yes.
That there was a very high error rate in that particular proficiency test, right?
There was a higher error rate, yes. However, my answers were satisfactory along with the 5 other examiners at my specific laboratory that took it as well.
Your conclusion in that case was, as in this case, that it was inconclusive, correct?
Correct.
Even though the...
Oh, so she's had more than one inconclusive result. Oh my God. Stop the presses. Holy shit.
Correct answer was that the bullets did not come from the question. The two did not match. The known in the question should have been an elimination.
The ground truth answer was yes, they were excluded. However, an inconclusive result in this comparison was extremely appropriate. The lack of quality and quantity of those individual characteristics never reached sufficient agreement, nor did it ever reach sufficient disagreement. So saying anything but inconclusive was not appropriate.
I see. And can you have bullets fired from different weapons that can have individual characteristics that look pretty similar?
There is occasions, yes, that tool marks that are made by 2 separate tools are similar, yes.
Could you go, and this is my last area question, Exhibit 19, page 26?
Your Honor, I'm requesting
Page
20 minutes
26.
for cross-examination. We're coming up on 437. That would be my request, Your Honor.
That's my last question. So,
All right, Mr. Burt. Thank you, Mr. McBride. I appreciate the heads up.
in your opinion, does this, the one on the left and the right, show matching individual characteristics?
Counsel, has this been admitted?
No.
Because I see it displayed. I just want to make sure, is this okay?
It's not been admitted, and I'm asking this question.
It's not on any screens because it hasn't been admitted, but clearly it can be on her screen.
Thank you.
So only to the witness and counsel table screen.
Page indicating that it was fired from the same weapon?
There are individual characteristics present, but without examining it in person, I don't feel comfortable making a conclusion.
Okay, how about the
He
next
tried to
page?
get her in a gotcha, and she said, no, that's not how that works, bitch. He tried to get her in a gotcha situation. He tried to say, oh, well, I know the answer and you don't. That's not how that fucking works.
Impeachment isn't as good as it was in his day when he could just tell the report like, do you remember this statement? You said this on this date to this detective. It don't work like that no more.
And I don't feel comfortable because I have not seen them in person, which is the appropriate answer. That's what I would say if I were her. I could make assumptions based on this, but because I have not put my hands on them, I have not looked at them, I have not seen them under a microscope with my own eyes, I do not feel comfortable. Perfect answer.
Physically in person and having an accurate representation of the entirety, I can't conclude in any answer.
And the last one, the third photo, page 28.
It's going to say the same thing.
Exhibit 19, page 28. Same question.
I do see individual characteristics. I do see some areas of agreement without looking at it further. I wouldn't make a conclusion. It's a holistic approach when you're examining items.
Would it surprise you if I told you that all three of those were fired from different weapons?
Again, I don't know any context to these photos other than what you showed, so I don't feel comfortable saying one way or another.
Thank you.
That's a very old style question. If I were to represent to you that it said this, would you disagree with me? That's an old style question.
Good afternoon.
Good afternoon.
Used to work back, it doesn't work.
Those last three photos that you were shown, had you seen those before?
I have looked at them probably back in 2024 when it was published.
Okay, that's a study. Is that what that is? Some
Yes.
sort?
It was a look from the Association of Firearm and Toolmark Examiners. It was a volunteer of photographs of people that did have an incorrect answer in that proficiency test.
Okay. And when you do an examination or a comparison, are you limited to one photograph?
No,
You actually have the item in front of you, correct?
that is correct, yes.
And you can manipulate it, you can turn it, you can look at every angle and every side of that item as you do the comparison. Is that correct?
Yes, that's correct.
And as you're doing that process, you're looking for as many characteristics that match or agree or disagree as you can possibly.
Angel Bug, who is that? Who's that? Say it louder. Who's that?
Find, correct?
Yes, it's a holistic approach. If I have a bullet like this case, I'm looking at every single land, every single groove impression, and doing an evaluation of each one of those, looking for areas of agreement and disagreement before rendering a conclusion.
Would it be responsible for you to reach a conclusion based on a single photograph of a very limited area of two bullets?
I would not feel comfortable doing that now.
Okay, I want to back up. How long have you, first of all, where do you work?
I work at the Forensic Science Laboratory in Washington for the Bureau of Alcohol, Tobacco, Firearms, and Explosives.
How long have you been there?
A little over 6.5 years.
Where did you come from? Where did you work before that?
Prior to working for ATF, I was a latent fingerprint technician, recovering latent fingerprints from improvised explosive devices, and I also worked as a crime scene investigator in Winston-Salem, North Carolina, and Anne Arundel County, Maryland.
How long did you have that position?
I think cumulatively it was about 5 to 6 years.
And before that?
Those are the only ones. I think it was about 6 months as a latent fingerprint technician, 2 years as a crime scene in Winston-Salem, and 3 in Anne Arundel County.
Do you have education and training before that position?
Yes, I have a Bachelor of Science in Forensic and Investigative Science from West Virginia University and have attended and graduated the National Firearms Examiner Academy, as well as done specific training at my laboratory.
At each of the positions you've held, have you had on-the-job training at the laboratories where you've worked?
I have, yes.
And will you describe what that training is like at the ATF where you are now?
Yes. So part of becoming a firearm and toolmark examiner for ATF was attending the NFEA, the National Firearms Examiner Academy, which is a year-long intensive comprehensive training program. I learned about historical cases, figures, and the evolution of firearms, fired ammunition components, and manufacturing. In phase 2, I worked 16 weeks of hands-on experience assembling and disassembling firearms, using a comparison microscope comparing fired ammunition components and tool marks, going on manufacturing tours, and participating in moot court. I worked on an independent research project and 4 practical exercises, and then presented that independent research project to a panel of experts and participated in 2 moot court sessions on 2 of those 4 practical exercises. Then specifically for ATF, I still work on my training, going through practical exercises and competency tests, working under trained firearms examiners at my laboratory, and also continue learning about any manufacturing evolutions or going on manufacturing tours. And I also participate in moot court for every single competency test that I work. Once all of that is complete, then I work on supervised case before moving on to unsupervised casework.
And supervised casework means what?
It means that the author of the final report will be a different examiner, but I am working on all of the work side by side and going through all the steps that are needed for that examination.
And in that process, you're having discussions and discussions about your work with a more experienced examiner.
Yes, it's an opportunity to work a case that has come into the laboratory, but still have someone there making sure I feel comfortable with everything and following every step necessary.
How long ago was that you had that you graduated from that supervised work?
I believe that was in 2022 or 2023. I'm not sure.
Do you supervise now others?
I do not have a supervisor capacity, but I have had the opportunity to now teach at the NFEA. I've been fortunate enough to participate as an instructor in the test firing module, the mini moot court module, and the comparison of bullets and cartridge cases.
Are you required to undergo continuing education in your position?
There is not a specific continuing education program. However, when the opportunity to go on AFTI's annual conferences and it allows it, I will go to those, as well as continually go to manufacturing tours.
Is this an area of science and forensics that is continuing to develop new techniques and advance in research?
Yes, it is.
And how do you stay up on those advances?
Part of the way to do that is to continue my membership with AFTI. Again, they do an annual training seminar recently, just in May of 2026 here in Baltimore, where there's case searches and studies that are presented, different manufacturing techniques, just new and upcoming research that is throughout the community, not just firearms practitioners, but also standard and technology researchers like those from the National Institute of Standards and Technology, or NIST.
And I think Defense Counsel has asked you a little bit about some of the publications that have given criticism is how he's phrased it, but given recommendations on how to improve the science in your field. Are you aware of that?
I am, yes.
And is there an effort to adopt those suggested improvements where they have merit?
Yes, AFTI especially takes those recommendations very seriously. If the PCAST asked for more specific design test studies, they said, yes, we will do that. I can think of just a few right off the top of my head that has satisfied those asks that they wanted.
Is your laboratory accredited?
It is, yes.
What does that mean to be accredited as a laboratory?
And accreditation means that my laboratory is held to an international standard of reporting, testimony, training, and proficiency tested. We have a large audit every 4 years through ANAB, or the American National Standard Institute, National Accreditation Board, but we also do internal audits, and we make sure there is some type of audit that we are staying in within those accreditation limits every single year.
There was a mention of proficiency testing. Are you required to do proficiency testing?
Yes, I am.
And are those specific as to what type of proficiency testing that you do?
Yes.
What are some examples?
We are required to take proficiency tests in all discipline that our scope enables, so serial number restoration and the comparison of tool marks, bullets, and cartridge cases.
Are there similarities and principles that apply to all aspects of tool mark analysis and comparison?
Can you elaborate on the question, please?
Well, let's say you're comparing what we've been talking about here, rifling on a bullet. Are the principles that apply to that area versus that also apply in tool marks analysis, say, of impressions of a handheld tool?
Yes, all of those comparisons are a product of a tool mark comparison. A firearm is nothing but a tool. So when you are talking about a cartridge case comparison, it's still looking at a tool and a tool mark. The tool in this case is the firearm. The tool mark is being left on a cartridge case or a bullet.
I want to draw your attention to Plaintiff's Exhibit 32. Thank you. Pulling up, and this has been published, it's been approved for publication at all 3 levels already, so we can,
No.
thank you. I want to ask you first about the inoperable condition. Did you perform that test fire?
I did, yes.
How did you receive this firearm?
I received it from another physical scientist in our laboratory.
Okay. And did it have a scope on it?
Yes, it did.
What did you do to determine if it was in operable condition?
In order to determine if the firearm is in operable condition, I will find ammunition that it is calibrated for. In this place, it was 30-06 Springfield, load that into the firearm, and then I fired any test fires into our water recovery tank.
Okay. And why did you choose a water recovery tank?
The water recovery tank is what is used to obtain bullet specimens. The water is going to slow down the bullet from its movement so that we can actually obtain the bullet, and it is supposed to cause minimal damage.
Why does it matter if there's minimal damage or more damage?
You would like minimal damage because that means that there's going to be less damage on the areas that you need to compare.
And that the evidence rounds that you, or in the bullets that you often receive in your cases, are the cases where there's a lot of damage to those bullets?
I have received cases with lots of damaged bullets, yes.
In this circumstance, the Exhibit 1 rifle, this Mauser 98 30-06, was it an auto-loading rifle or a bolt action?
This was a bolt action rifle.
Exhibit 2 cartridge case, let's see here.
And we know that already. Okay.
If you'll turn to page 2, and the comparison was inconclusive.
There was no further testing that I could do, no.
Is there further testing that could be done in the field?
There is the possibility of using a 3D system to visualize the individual characteristics on the bullet.
Do you have the capability of doing that at your lab?
My laboratory currently does not have that capability.
Do you know if the FBI lab does have that capability?
I believe they do.
Defense counsel put up a list of potential firearms that could have fired this round, or this bullet. Is that list comprehensive?
It's not an all-inclusive list.
And does it mean that,
Gotcha.
that this round? I'll leave it at that, actually.
They just talk really slow.
It is.
Yes, I do have a demonstrative. May I use that?
You got that with you? Yes. Yes, please, go ahead.
And apparently
So this is a demonstrative of a bullet. So a bullet jacket, it would refer to the outside of the bullet. Inside the bullet would be the lead core. So when I'm referring to the jacket, it means that I've only received that outer portion. I did not receive any of the lead core intact with it.
In this circumstance, you received a bullet jacket fragment. What does that mean that it's a fragment?
Fragment means I don't have the entirety of that jacket.
And can you testify as to why you don't have that entirety?
No, I cannot.
And it also, your report also says that there are 4 lead fragments. What is this? Why would you have lead fragments?
So the lead fragments, the lead would be from the inside of the bullet, that core. Occasionally when the bullet reaches its final destination, it can split, and some of that core might be pulled off of the jacket and be found where it landed.
And would you be able to gather information from those lead fragments that could identify them as coming from this particular firearm? Would you expect to be able to make that comparison?
I would not expect to see any characteristics that would help me reach a conclusion, no.
Why not?
Because the lead core is on the inside of the bullet, the landing grooves are going to be imparted onto the jacket or the exterior. So when it's moving down the barrel, the inside is not coming into contact with rifling whatsoever.
In this case, do you have a verification step where your work is reviewed by another analyst?
We do, yes.
And were your conclusions in this case verified by another analyst?
Yes, they were.
Another gotcha. They're incredibly slow, which is another reason that this is taking forever.
Destroy the evidence that you're reviewing?
What do you mean?
Well, prevent it from being tested in the future.
No, I would not expect anything that I've done to prohibit more examination in the future, no.
But in general, you say you peeled back the petals, I think you said, of the bullet jacket because it was so crumpled. If that's-
Yes, I think if anything that lends to a better comparison process. It is a very well-known practice amongst firearm and tool mark examiners. Without doing a examination like that in preparation, no one's able to see the marks that are needed for the comparison process.
Okay. And reaching the conclusions that you did in this case, did you follow protocols and practices that are required by your position?
I did, yes.
Nothing else? Mr. Bird.
One was that your work is peer reviewed, right?
Yeah,
There's a peer
Basically.
reviewer, a second
Yeah,
reviewer,
slow.
It is a verification process.
verification process. And you know, in this case, we requested to produce the case file from your reviewer so we could see whether it was accurate or not. You're aware of that, right?
I am not, and the verification process does not require that the verifier has case notes. Their case notes would be within mine, and it's just an author verification chart.
Well, you wrote a memo to Mr. McBride dated May 19th, did you not, in which you said in answer to our request for the reviewer's work product that ATF laboratories do not release materials concerning technical reviewers or verifiers. And you went on to state, did you not, that we don't even release the CVs of who the reviewers are.
So that is not authored by me. That is our ATF procedures and protocols. If that was an email that came from me, I am just verbatim what our quality assurance manager has said.
Do you think science works best when it works in secret?
Oh,
Objection argumentative.
Do you think evidence works best when it works in secret? I could turn that around and ask you the same fucking thing.
Counsel?
It goes to the issue that was raised on cross-examination, which is my work was peer reviewed. So how do we evaluate the
That's
strength of
argument.
that assertion
Yes, it doesn't
when they
mean-
refuse to hand over to us the work product of the reviewers or even identify what their credentials are? That's relevant.
Well, I'm not agreeing or disagreeing with that, but the question itself was argumentative because we can look at the question, working in secret.
Let me rephrase.
Okay, so I'm going to sustain the objection because of the
Sure.
phrasing. It is inherently argumentative. And it
So
wouldn't
he's
be
just saying that
Science
What I can say is that they are employed at my laboratory. They're under the same scrutiny of proficiency testing, went through the same training with competency and practical exercises, so they are a trained and competent examiner.
Okay. They don't have any work product they show, but your protocol calls for, does it
So he
not,
does
documentation of
something
whatever it is they
saying
did.
And that
He's just pissed because he's running out of options of ways to discredit her, and he's just getting.
that's why I get argumentative. He probably didn't even realize he was argumentative because who knows?
He's just an asshole, an overpaid asshole.
I
is
used to
included
like
in my case file.
Right, but not the reviewer's work product.
The reviewer's work product is a verification sheet. If I like, I can refer to my case notes and find that specific page number, but that would be the only work product that they would have in this case.
I see. Now, you said two things about the PCAS report on cross-examination. One was that, if I understood it, that the PCAS findings have been addressed in subsequent studies. Did I hear that correctly?
Because one of the recommendations was to further, actually, I think the recommendation was one more black box study to show the foundational validity of firearm and tool mark examination. And since 2016, several have been published.
All right, let's look at that for a second. First of all, they didn't recommend, they found, did they not? Quote, PCAS finds that firearms analysis currently falls short of the criteria for foundational validity because there is only a single appropriately designed study to
Okay, I am not gonna fucking like I'm not going to try to be a lawyer. However, if this were my case and the only thing that was on my side was the fact that the firearm the bullet analysis was inconclusive, I would not be trying to destroy uh, the credibility of the examiner that basically gave me my only out. Am I interpreting this wrong? Please enlighten me in the chat if I'm misinterpreting this. But with everything else that we've heard all week, literally the only thing that is on their side is that the bullet fragment comparison was inconclusive.
I would do what they
I
did
would
the 80s trial research, and the state had all this California, of course. The state had all this ballistic evidence. So what did the defense do? They hired better experts.
I would not be destroying the credibility of the only person who gave me an inconclusive result.
Yeah.
Versus
I
a yeah, they matched.
I could see there were multiple inconsistencies and contradictions. Then go right ahead. But
Like that would not be my strategy to destroy the credibility of the one scintilla of evidence that might be in favor of my client. The fact that it is an inconclusive result means you can't be for sure that it matched.
yeah, that would help. That helps you. That goes in your favor.
I wouldn't like I said, I'm not a lawyer. April, if you're listening, please help me out. Please help me out. Would you, as if this was your case, would you be destroying the credibility or attempting to destroy the credibility of the only ounce of evidence that might be in your favor? I'm dumbfounded here. I'm like, are you this stupid, or are you just pissed so you're burning the whole fucking house down? Are you cutting off your nose to spite your face?
I will say he's no longer my favorite. Well, I will say he was never my favorite, but he did.
Yeah, and this is once again, this is more of a trial argument, in my opinion. Like I said, I'm not a lawyer, but watched enough trials to know the difference between a probable cause hearing and a trial.
Him decades ago.
No way. Thank you. Thank you. Hey, Spawn. Okay, like for that, it's not even about being a lawyer. It's having freaking common sense. It's how to win an argument, and women know how to do that. I think it's how to win an argument. And if the only thing that's on my side, I'm not going to destroy the credibility of the only thing that's on my side. Like no.
Measure validity and estimate reliability. The scientific criteria for foundational validity requires more than one such study to demonstrate reproducibility. Isn't that what they found?
That is what their finding was, correct.
Okay. And then after that report was published, in 2017, they came out with a second report because people said, oh, the literature already exists, you missed it. And they said, no, that's not true. Isn't that right?
They concluded.
Relevance to the preliminary hearing. We're now well into 702 argument.
He raised this issue on cross, Your Honor. He clearly went beyond the 2009 reference that the court allowed and opened this area up. And I don't think it's fair for him to be allowed to do that without me being able to respond to it.
Thank you. On cross-examination, that door was opened by the state, and so I will allow limited questioning on recross or redirect, however we want to label this. So you may proceed. The objection is overruled.
It'd be like, stop.
In 2017, they filed a second report responding to assertions by people in your profession and others that they had missed or the studies had already been done. Isn't that true?
Yes, PCAST did a 2017 addendum to their 2016 report, reiterating that they believe that the only way to properly empirically test the science is through these black box studies, and that they would not take into consideration the numerous amount of work and validation studies done over decades that the firearms community has published.
And a bunch of other studies were done, right?
Correct.
We're
And-
almost done with this part.
In response to those additional studies, there have been continual criticisms of the methodologies of those studies. Isn't that fair?
Yes.
And you've read, for instance, well, first of all, you attended, I see, a webinar by the group that did some of the critiques. Remember that?
Which webinar are you referring to?
You attended a webinar, I believe, it's a webinar hosted by the Center for Statistics and Applications in Forensic Evidence, 2021.
Correct, I did.
And that group has published a number of studies right up to 2026, for instance. Their study in 2024 called Methodological Problems in Every Black Box Study of Forensic Firearm Comparisons, in which they concluded that the field still was not reliable, despite the studies that you referenced. Isn't that true?
That is the author's opinion, correct?
Right. And they're not the only ones. There have been other groups of statisticians who published articles right up to 2026 saying that the studies that you referenced are unreliable. That
Yes.
their methodology of those studies is flawed and cannot be relied upon to support the science of tool mark comparison, correct?
Yes, there has been studies to say that they believe there is flaws in the black box studies and stuff, but there has also been plenty of research done to say the opposite.
And lastly, you mentioned that, or it was brought out that you have training and experience, right?
Correct, yes.
Do you agree with the conclusion stated in the section of the report, the PCAP report, that neither experience nor professional practices can substitute for foundational validity? Do you agree with that?
I do, yes.
You agree with the conclusion reached in the PCAP report that a forensic science discipline that has an error rate higher than 5% is not reliable?
I don't know that I have opinion to that because I think it's a little on the broad side. I don't know what you would consider high as far as the percentage.
Well, I'm referring to the statement at page 151 where they say methods with a high false positive rate are scientifically unreliable for making important judgments in court about the source of a sample. To be considered reliable, the false positive rate should certainly be less than 5%, and it may be appropriate that it be considerably lower depending on the intended application.
I would agree with that statement.
You would agree with that. And you also lastly reference your knowledge of the study by the AFTE of that proficiency, the one proficiency test which you have taken on bullet comparisons, correct?
Correct.
And the error rate in that particular study, proficiency test, was 20.4%, correct?
Correct.
For item 2, 18.2% for item 3, and 18.9% for item 5.
I believe those were the results. However, I don't agree that proficiency tests are what are used for validation studies to show foundational validity.
So if the error rates are high, then they shouldn't be relied upon to show invalidity, but they should be relied upon to establish that your experience means that your science is valid? Is that what you're saying?
Foundational studies are looking at, just as PCAS said, those black box studies, different test design, all of which firearm and toolmark community has conducted. We've looked at cartridge cases, bullet, pristine samples, damage samples, and different firearms. Proficiency test is looking at the accuracy of an examiner's results, not foundational validity.
You would agree that an error rate of 20% is unacceptable, would establish unreliability, correct?
I would agree that those results need to be looked at to see where that error was coming from.
Right. Okay, thank you.
And
Thank you.
Smith,
Anything
if
further
you
for this
ever
witness?
think for the red card.
And Mr. McBride, I'm going to limit you because your objection to going outside and going to 702, you opened the door, but I've got to close that door to some point. So I will give you a limited number of questions. We need to come to a close.
Your science has been peer reviewed and viewed favorably by numerous publications and studies across the country and across the world, correct?
Correct, yes.
No more questions.
Witness be excused. Thank you, Mr. Burt. Thank you, Mr. McBride. And thank you for being here. You're excused. And we'll stay in court for these 5 minutes just because it would take longer to let everyone go and then come back in.
All right, now they're going to argue about. I think they argue about next steps.
Yeah.
After the preliminary hearing wraps up, from what I
Are we going to argue the bind over tomorrow? And the state would be prepared to argue bind over tomorrow.
All right. Well, I appreciate that. In regards to trying to budget time here, how much time does the state anticipate? Obviously, there's one more witness, so I'm not going to.
If it's a short witness, Judge, I don't think it should take us the entire morning. But we would be prepared to argue tomorrow morning at the close of evidence or first thing in the afternoon.
And how much time do you anticipate that argument being? Again, a rough estimate. I'm not holding you to the exact number. I'm just trying to see how close are we to the 5 o'clock, because I'm going to ask the defense the same question as well.
It wouldn't come close to the 5 o'clock hour, Judge.
For just you or for both?
For argument?
Yes.
Both of us.
Okay. All right. Well, I'll turn it. Thank you, Mr.
If we have to argue 2 hours apiece for bind over, there's a problem.
All right. Thank you,
I'm
Mr.
saying-
Randall.
Thank you.
To the defense, I'm just getting an estimate. I'm not holding you. I'm not going to time you to this, but I'm just trying to see as it relates to 5 o'clock and for argument for bind over tomorrow afternoon.
Understood, Your Honor. Our request, the defense request, is that we be allowed to submit briefing. There are some legal issues that we would like to brief for the court prior to the decision on the bind over. We're open to briefing, page limits, time limits, all of that, but we would like that opportunity because there are some legal complexities involved here.
All right. And if and I'm going to ask the state, but if the state, well, I'm not going to assume anything. Thank you.
I believe the state is going to object to that, Your Honor.
So what I hear you saying is you wish to. Well, I don't want to assume. What it seems like you're saying, I want to be clear, is you're waiving oral argument and just doing briefing.
So generally, Your Honor, in cases with multiple counts that are pretty complex issues of law, I have asked for briefing and the opportunity for an argument. We can set time limits on that as well prior to bind over. I've done this in multiple other cases before courts in Utah, and that is my preference to make sure we get the law right.
And so how much time, if you're asking for argument, that in addition to briefing, I'm trying to get the total universe of what's
Trying to
in
make
what's
sure
in
that
front
we
of
have
me.
fucking
So
time.
I anticipate that I agree with Mr. Grunander that I don't think an argument would take more than a half day.
Sorry.
Should take less than that, particularly if we're briefing issues beforehand. So I don't know, 2 hours for argument total.
I'm so sick of the judge. The judge needs to put his foot down. I asked you you got to treat them like toddlers. I asked you how much time you needed. No, I asked you how much time you needed.
And somebody said earlier, I can't remember who was. They said you got to be careful with being abusive to attorney. It's not being abusive. There's
It's
many
not
judges.
being abusive, that's being direct. I asked you a yes, like, I asked you a direct question. I want a direct answer. I'm not asking you a multiple choice question and getting an essay answer. And I have to go take care of the little. I will be right back.
Yep.
All right. Thank you, Ms. Visser. Turning back to the states, what is, you've heard from the defense.
Again, Judge, the state would prefer to argue tomorrow. We think the court has all the evidence before it and could make a bind-over decision after oral argument tomorrow. If the court decides that briefing is necessary, I believe the court reporter could have a transcript available as early as Monday of next week at an expedited, on an expedited request. With that said, each side would need 2 weeks to. We're the moving party. We would prepare a motion in support of bind-over. There would be a response and then a reply. So we're probably 6 weeks out before we can actually argue before bind-over. We would rather not wait 6 weeks to argue bind-over.
All right, and basically they're arguing stuff that doesn't have anything to do with any of us right now and is irrelevant to.
Yeah, that just means we're not going to have a ruling today.
Yeah, they're arguing stuff that is irrelevant to the actual purpose of this hearing. So, no, they were arguing stuff that the judge was asking, well, for the interest of time, how much time do you need to argue? And, well, I've done this in front of, no, the judge needs to put his foot down and be like, I asked you a direct question. I didn't need an essay answer. I asked you how much time do you need?
I'm gonna have to watch this session because I think they do give a date for what's next. Maybe you say it again today, but
It's like they're getting paid by the word.
yeah, I believe they're gonna have time to file briefing motions and stuff about objections to bound over and why he should be bound over. So they're not gonna have to be a ruling today.
However, we I have to go because we have to eat something. The next part of this is day 5. I set it up for 1:30, which is about 45 minutes. Gives me enough time to stand up, move around, get something to eat, spend some time with the little.
Yeah, I'm gonna eat some lunch.
And come back that for the next installment of what the fuck is happening in Utah. So y'all have a great rest of your morning. I will set us up to redirect over to that other stream.
Yep,
Hold
see
on.
y'all in about half an hour.
Hold on. I am do you ever get like ass backwards when you're
Brain
trying to
fart.
do stuff?
Yeah.
And you're like redirecting to yourself in the wrong direction? That's just where we almost redirected to ourselves backwards. Yeah, it's about that time. So I will see you guys in about 45 minutes. Food sounds good.
See y'all.
I have had this today.
What is that?
However, I have drank all of this already. 40 ounces of water and a element.
Oh, I thought you were gonna say you drank some beer. I'm like, this early in the morning?
Nope, there is nothing left in this container and I need more water. So I will see you guys. Squid's gonna raid Squid. Yes, tell Squid that I sent you. Tell me I said hi. And y'all have a great rest of your morning, and I will see you in like 45 minutes.
See y'all.
And I will send you the new link, Flash fan.